on the TV in front of them? Do we turn on the TV in front of them? Okay. I know we didn't. Testing, testing, 1, 2, 3.
Everyone. Our first case for argument this morning is 13 Investment Company versus Foremost Insurance Company. Mr. O'Malley.
Good morning. My name is John O'Malley. I represent the plaintiff appellant 13 Investment Company. This is an appeal from a grant of summary judgment to the defendant Foremost Insurance Company. 13 Investment Company is a small family-owned business here in the Chicago area. It's a family-owned business. They put some money together to refurbish homes. Foremost Insurance Company is a fire insurance company and a subsidiary of another very large insurance company. I bring that up because Foremost Insurance Company is in the business of adjusting fire loss claims. My client, 13 Investment Company, does not and has not been in the business of submitting fire loss claims. And that is a significant factor here because despite the insurance company coming before this court and saying that notwithstanding their insurance policy, notwithstanding the duty of good faith and fair dealing, what the insurance company said in their response brief was quite significant. They claimed, and I'll read it to you, Foremost had no duty to communicate with 13 regarding the insurance claim because 13 was represented by a public adjuster. Such is not the law. Such should not be the law. They're obviously coming before this court suggesting that because there was a public adjuster involved, that their duties under their insurance company, for which they receive premiums, and are in the business of adjusting and handling fire loss claims, that their duties under that insurance policy should be relieved.
Mr. O'Malley,
Yes.
Your client signed a contract with Paramount, correct?
Yes, my client signed.
And in that contract, your client appointed Paramount as its agent and representative in dealing with the insurance company, correct?
Yes, it did.
And it also agreed that we direct any insurance companies to include Paramount Restoration Group on all payments on said claim.
That is correct.
So I guess my question here, ultimately under the UCC, is how do you deal with Article 3, Section 414C, which looks like it applies, and why didn't you sue the banks instead?
Well, that's a very interesting question. The reason we did not sue the banks is because we didn't know that the check existed until significantly later. So when there is an argument that Paramount Restoration was the agent and was a loss payee, certainly it was a loss payee. There were 3 loss payees on that check. There was Paramount, there were 13 Investment Company, and there was the mortgage company. There is no argument made, nor could there be made, that Paramount was the agent of the mortgage company. So that is very significant.
What does that have to do with the problem here?
Well, because the case law and the act and their affirmative defense, which they're relying upon a section of the UCC, which they did not allege as an affirmative defense, did not mention throughout the entire history of the case.
Everybody knew that you were claiming you had not been paid. They claimed you had been paid. No prejudice in the way that whether it's a defense or just a denial of your client's allegations. Let's forget about the procedural problem. Focus in on the UCC problem.
Well, the court in the cases that we have been talking about talk about and the cases cited by Foremost talk about an agent. But here, they're not an agent of all the co-payees.
We don't need to worry too much about agents. Let's look at 3-414C. If a draft is accepted by a bank, that happened here, right?
Yes.
The drawer is discharged. That's from the underlying obligation to pay, correct?
Under certain circumstances, yes.
Well, regardless, and this is my question about circumstances, regardless of when or by whom acceptance was obtained. So why doesn't that govern here?
Because we're not suing on the check. We're suing on the insurance policy. So the other section of the UCC applies, which they raised, which their argument is that 13 agreed to take the check, and therefore that Foremost was relieved from their underlying liability. Here, they're not relieved from their underlying liability for several reasons. First, 13 did not agree to take the check in satisfaction of the liability. It did not know it existed.
Is there any disagreement about the settlement? The settlement of your client's claim with the insurance company? There was agreement on an amount to be paid, correct?
There was an agreement on the amount to be paid, yes.
And that was the amount of the check
That is correct.
that was delivered to your agent.
It was apparently delivered to our agent, but as I pointed out, without our knowledge and without our
And
agreement.
whose problem is that, I guess is the question.
That is Foremost problem. And I'll tell you why. Because they're an insurance company that owes obligations to their policyholder.
But that's
And-
where the agency question does come in, because if that's your argument, then agency law forecloses it.
Well, in this situation, we're dealing with undisputed testimony from my client who talked to the actual adjuster. And the adjuster says, this is how Foremost Insurance Company, in the business of handling and resolving fire claims, is going to pay this loss. We are going to pay it in installments after inspections. And my client, being told this by Foremost, who's in the business of adjusting claims, said, that works for me. That sounds good because I want my property repaired. So another very significant factor is we have Paramount Restoration, who is wearing a public adjuster's hat. Paramount Restoration was also hired to be the reconstruction contractor. So that's very significant here because when you have a principal discussion with a principal and the principals talk and the principal of Foremost Insurance Company says, we are going to pay this in installments, in draws, after inspection of the work, my client and the undisputed testimony is that he understood that, he relied upon that.
Did Paramount do some work?
Paramount did some work at the facility, and when my client, and the reason my client even discovered that these checks had been issued, again, there's no dispute that Foremost didn't pick up the phone, didn't send an email, didn't send a copy of the check.
Can I just
Sure.
slow you down and let's just take this a step at a time. They did some work. How much of the repair work was done?
There's at least $100,000 worth of work to go,
To go.
according
Okay.
to my client's
And
testimony.
Paramount has disappeared?
They have been, yes, yes.
You can find them, can't find them, or they're judgment proof?
Absolutely judgment proof.
Okay. So, but let me, well, I'll try one more time. Under 3414C and the related provisions in the UCC, it looks to me like your remedy is against the bank that negotiated or that honored the check with the signature of Paramount and the forged signatures of your client and the mortgagee.
And my answer to that is no, and there's a technical reason, which is my client never had physical possession of the check. And as a result, it is not in a position to go ahead and to chase after the banks. Now, who was in position to go after its bank is Foremost. And the suggestions that have been made that this small policyholder should have to chase down these judgment-proof individuals raising claims
whom he made his agent, right?
He was an agent for purposes of the public adjustment. He was not an agent for purposes of the construction work. That was an arm's length agreement, and Foremost was advised of that because Mr. Starzak and their adjuster had a discussion on the phone. And again, this is undisputed. This is undisputed testimony from my client, and there was no contrary testimony proffered by Foremost. And this court can and absolutely should take an inference that the absence of that type of evidence, which is clearly available because this was their adjuster, their employee, was available. But nevertheless, we're dealing with a summary judgment on an affirmative defense where there are clearly questions of fact. But I
Mr. O'Malley,
believe,
question about the law. We're sitting in diversity. Illinois law applies. There are 2 Illinois appellate court decisions. Case law is somewhat sparse. It looks like you're really rising and falling with this VFS case from the district court from the Middle District of Florida. Is that correct?
I am relying on the case for sure, but I also believe that if you take a look, and I have argued in my brief at length, that those 2 cases don't apply because they're distinguishable. The reason being the plaintiffs, the injured parties in those cases took the checks. So we have a medical group received checks at their offices, gave them to their employees skedaddled with the money. The other one was a policyholder who told the insurance company, send the check to a contractor. I agreed to take the check. Here, my client never agreed to take the check, which is what the statute provides. And again, I'm not suing on the check. I've never had the check. The check was pilfered and gone. But here we have a scenario where I'm suing on the underlying obligation, and the insurance company has the burden of proof that that section of the UCC applies. And factually, those 2 cases don't apply, and therefore I think we're back, because that new section of the UCC doesn't apply, we're in a scenario here where the pre-existing case law provides that we can bring an action on the underlying contract.
Pre-existing meaning before the UCC?
No, before the adoption of the section about taking the check relieves them of the...
So do you distinguish between, let's take the affiliated health case, where the employees of the insured took the checks and negotiated them. They are, as an employee, they're an agent of their employer, correct?
Yes.
Paramount is an agent of you. Is there a difference in the law between agents who are employees and those who are independent contractors?
I think the difference in the distinguishing factor in the case is that the principal, when affiliated medical, requested that the checks be sent to a specific address, and they were. Then they were taken. In other words, they came into the possession of the affiliated, who was the plaintiff. We never received the checks, therefore our causes of action against others don't exist. I saved a few minutes for rebuttal. I have, sit down, I'll come back. Thank you.
Mr. Orlando.
Good morning, Your Honors. May it please the Court. Tom Orlando for Appellate, Foremost Insurance Company, Grand Rapids, Michigan. 13's agent signed the endorsement of 13 on the check and kept the insurance proceeds. And the issue here is whether Foremost must atone for the sins of Paramount. The answer seems obvious from the question, and it's obvious in the law that Foremost does not need to atone for the sins of Paramount. Paramount appears to be...
What would happen, Mr. Orlando, if it were the mortgagee suing you?
The result would be the same, and that's the Parkway versus State Farm case, which I think is really on all fours with our case. That's the Illinois Appellate Court. Also a co-payee situation with 3 parties on the check. The insured, in that case, the contractor, and the mortgagee. So it does not appear that there were any agency relationships involved. In that case, the contractor forged the endorsement of the mortgagee, and it was the mortgagee that brought the suit against State Farm. And the appellate court relied on the UCC provision 414 and 309 to say that State Farm's obligation was discharged under the provision that Your Honor read into the record. The agency, there was no agency issue there. The agency issue, I think, has come into play in this case because 13 has traveled to Florida and Texas to find some case law where there were no agents involved, and then subsequent law in those states have said, well, when you do have an agent situation, then you're back into this UCC provision. Well, we do have the agency issue here between our insured, and Paramount.
But ultimately, you don't think it matters.
I'm sorry?
Ultimately, you don't think that matters. You win.
It doesn't matter, because even if there wasn't an agency relationship, the Parkway v. State Farm case addresses that issue. It doesn't matter under Illinois law. The parties to go after are Paramount, and by the way, Paramount, the owner of Paramount, sat for a deposition in this case. Whether or not Paramount is judgment proof, that's not in the record. I don't know that. It's not in the record. But the gentleman sat for his deposition. He acknowledged he signed the checks, and of course he claimed he took the money because he had done the work, or done a lot of the work on the property. This is a dispute between 13 and its public adjuster who handled the insurance claim and the same company who's done the restoration work.
Is there any remedy in your view against the banks for 13?
I believe there is. Again, under the Parkway v. State Farm case, the court said the remedy certainly lies against the party that forged the endorsement, but then it also lies against the banks in accepting it. And the court actually, in that case, actually addressed whether or not there is a remedy against the insurance company under the UCC in this situation, and that's where the Section 309 came into play, which deals with lost, destroyed, or stolen checks. If the check is somehow lost, destroyed, or stolen, never gets to a party that's on the check, one of the co-payees, then that's a situation where under the code, the payee can come back against the drawer. Not under the insurance policy. And of course, that's significant here because this is a complaint where 13 alleges my client has breached the insurance policy. The Parkway case says no. Once you're discharged under 414, you have discharged the underlying contractual obligation. That's now gone. But if you are in the lost, destroyed, stolen situation, you may have a remedy, you being the payee, a co-payee, may have a remedy against the drawer. But in that case, the check wasn't lost, destroyed, or stolen. It was in the record.
As you read it, under 309, if the check gets to one of the payees, that takes you out of 309. Is that right?
That's right. And in our case, the check is in the record. Obviously, it was negotiated by Paramount. Again, there's no dispute about that. Paramount negotiated the check, took all the funds, said so under oath. There's no dispute about that. The front and back of the check is in the record. It wasn't lost, destroyed, or stolen. One of the co-payees endorsed everybody's name and took the proceeds. And that's squarely within the Parkway case, that under that situation, there is no remedy under 309, and there no longer is a remedy under the policy. So there's no remedy for 13 here under the UCC. And going back to agency law, I do want to comment on what was quoted from our brief about communications with the insured. Of course, foremost, as the insurance company is required to communicate with its insured, the statement in the brief is about agency law. When the insurance company speaks with the insured's agent as an operation of law, it is speaking with the insured. It's black letter agency law. There is no dispute here, and I think Your Honor touched upon it, that there is a covered fire loss. Nobody disputes that. That the amount of that fire loss on the building was $150,000 and change. There's no dispute about that. That's settled. 13 doesn't argue that that's the wrong amount. There's no dispute that Paramount belongs as a payee on the check. As Your Honor pointed out, that was in the contract, and 13 concedes that. They belonged on the check. The issue, the argument is that there was some duty to communicate that the check was being sent to the agent. There's no law that imposes that requirement. There's nothing under the policy imposes that requirement. To me, it's analogous to litigation where parties settle a case, and quite often, I'm a defense attorney, I do this all the time, I know the check goes to plaintiff's attorney to handle the proceeds with his client. It's no different here. A public adjuster is a licensed professional under the law of Illinois. So he's an agent by operation of this contract and this here in the relationship, but a public adjuster is a licensed professional, has obligations under the statute to put funds in a trust account similar to attorneys. So foremost would have no reason to think that when it mailed the check to the public adjuster and agent of its insured, that the public adjuster was going to take the funds. It would have no reason to believe that professional would do that. This is how the business is done on a regular basis. There simply is no requirement for my client to have communicated anything directly with the insured that it wasn't already communicating with the public adjuster.
Mr. Orlando, aware of any statutory or regulatory investigation of the adjuster or any type of punishment that's in the offer?
In this case?
Yes.
I'm not aware of that. It's not on the record. I'm not aware that 13 has taken any action. I do believe that public adjusters are regulated by the Illinois Department of Insurance, as are insurance companies. I do not know if 13 filed a complaint against them.
Thank you.
Plaintiff, excuse me, Mr. Orlando, but plaintiff is telling us that there was an oral agreement to modify these arrangements. Could you address that?
Sure. The owner of 13 has testified that he had this discussion early on in the claim process where the adjuster for Foremost told him that when payments would be made at some point, that they would be made in installments. That's disputed by that gentleman. In that sense, we have a fact dispute about who said what in that phone call. So the issue on summary judgment then is, well, let's assume that conversation took place and that representation was made. What does it mean as a matter of law, and what does it mean for Foremost obligations? So we start with the contract. There is a written contract here. It's the insurance policy. The insurance policy does not say anything about making payments in installments. The insurance policy is clear that my client has an obligation to pay the loss and must pay that loss when it's determined. Under Illinois law, my client is obligated to promptly make payment when the payments are determined. My client has no right under the policy to sit on the funds and to tell an insured, well, we're going to pay you in dribs and drabs over time.
And act as your construction manager.
I'm sorry?
And act as your construction supervisor.
And in this case, act as the construction manager, which imposes a new obligation on my client that's obviously not in the insurance policy. That's not what insurance companies do. They do not act as construction managers for the restoration of property. There is no consideration. Well, to start off, this is an oral issue. This was not put down in writing. There's no dispute about that. In order to modify the policy states it has to be in writing. That doesn't exist. And beyond that, there's no consideration here. My client already had an obligation to pay this $150,000. It was a pre-existing duty to then say, well, we're now going to act as your construction manager and we'll pay it in installments, an amount of money that they already owe. Under the pre-existing duty rule, when you already have the obligation to do something, to take on some additional duty but not change the amount or change anything else, that's not consideration because there was a pre-existing duty to already pay this amount of money and to pay it up front, not to pay it in installments. So I think the representation about what my client said is dubious. It is in the record, so it's there. I suspect that the gentleman, to give him the benefit of the doubt, may have been confusing my client with his own public adjuster in the days following the loss, where the public adjuster said to him on the construction side of this, when it was understood that the public adjuster was going to actually do the work, that when the money comes in from the insurance company, we'll pay ourselves in installments as we do the work. I suspect that's what happened, but the record says what it says on that. And on that point, the Paramount was terminated by 13 from the construction project. So they didn't run away. The underlying dispute is over the fact that Paramount started to do some work and they were terminated from that job. They took the money. They wanted to be paid for the job. This is a dispute between 13 and Paramount. It's a construction dispute. It's a contract dispute between them. My client should not belong in this case. I can briefly address the waiver issue if the court has any questions on that. I think it's an interesting issue because the word payment is in Rule 8, but I think in this case, I interpret Rule 8 to mean that you only need to assert an affirmative defense that's listed there if you're actually in an affirmative defense situation. And in this case, there's an allegation of failure to pay, and we denied that allegation. The parties were joined on the complaint and the answer. There was no need to assert anything as an affirmative defense. And under those circumstances, we don't believe that it is an affirmative defense, but even if so, I think Your Honor expressed our position on this. which is that there was no prejudice. 13 was able to make all the arguments they needed to make. Everything's in the record. They had their day in court, and we would ask this court to affirm the judgment of the district court.
Thank you. Mr. O'Malley.
In counsel's comments, there was a lot of arguments about what the record provides, and I think that makes it very clear that there is, at the very least, a question of fact. And therefore, summary judgment on what we all agree is an affirmative defense should not have been granted. Counsel talked about the Parkway case. I mentioned it earlier. What the Parkway case is, I think it's important. It says the loss payment provision of the policy expressly applies only to the named insureds under the policy. Foremost named insured here was 13. The court held that 1310 applied because the checks were delivered pursuant to the named insured's instructions to the defendant. Here there were no instructions to the defendant. What happened here is 13 was told how the claim would be adjusted by a party in the business of adjusting claims. Had no reason to believe that this was inconsistent with any type of practice. I further note that the cases and the distinctions that we have here, we have to draw a very careful distinction. The cases that counsel and Foremost talk about the individual who designated the agent to receive the actual physical check should be the one on the risk. Here, that never happened. The way this loss could have been avoided is by the simple fact that the insurance company could have picked up the phone, could have let its named insured know that the checks were issued. And if they were forged, then the insurance company has their rights to go against their banks, and that is the best way to have avoided this loss.
And why is it that you cannot go after the banks?
There's the technical provision is because we would have to have brought an action for conversion. We never had the check. We can't bring an action for conversion. Furthermore, by the time that my client learned that these checks had been issued, they had been the time limit to go back against the bank had expired. So I see my time is up, and if you had any other questions, but thank you for taking some time this morning.
Thank you. Our thanks to both counsel. The case is taken under advisement. We'll move to our second case this morning. Crothersville Lighthouse Tabernacle Church versus Church Mutual Insurance Company. Mr. Tatum.
May it please the court, Josh Tatum for Lighthouse Tabernacle Church. Lighthouse Tabernacle asks the court in this exceptional case to excuse forfeiture, correct the plain error that allowed Church Mutual to benefit from its own delay in preventing its policyholder from rebuilding as soon as reasonably possible after a fire destroyed its place of worship. Taking into consideration Church Mutual's own delays, it did not demonstrate that the church failed to rebuild as soon as reasonably possible beyond a genuine dispute of material fact. The district court granted judgment on those grounds only because counsel below did not sufficiently point the court to the facts that create that dispute. But this court can find disputed facts within Church Mutual's own designated evidence. Whether the church took a reasonable amount of time to rebuild in light of all of these circumstances presents a question for a fact finder, not appropriate for summary judgment.
Mr. Tatum, do you rely at this point on any evidence that is not already part of the record?
No, Your Honor.
Okay. Do we know whether Attorney Smith had any malpractice insurance in effect?
It's not in the record, but yes, he did.
I'm glad to hear that.
Not sufficient, yes. We are too, Your Honor. It's not sufficient to cover the damages in this case. And of course, as this court is well aware, Mr. Smith has more than one client who is unhappy with his performance.
What's the status of the reconstruction effort at this point?
The church, again, not in the record, Your Honor, but it has begun to rebuild and is on its way to completing that. It had to take a more modest approach than it would have otherwise, and do this in phases and take out loans to do so. But that is not really the question here. The question is it a reasonable thing for a policyholder to do to wait for the disputes about the cost of replacement to be resolved and for the insurance company to close its investigation before starting the demolition?
Obviously, I understand your position on that, but the larger question here is certainly about when courts can and should rescue a client from its own lawyer's mistakes. Mm-hmm. What limits do you see to your theory here? Because frankly, what concerns me is that it looks as if everybody can get a mulligan, at least if they are willing to blame their lawyer, or at least if they don't get a mulligan, they at least have a chance to argue for one and put the other side to another round of litigation.
I would start with this court's broad discretion and the exceptional circumstances here. Mr. Smith below did raise the delays. He just didn't point to the evidence in the record that was, again, part of Church Mutual's designated evidence. And this court is the one that removed him. The church is not the one that decided to fire him from this matter. There's a special relationship between the insurer and the
We removed him
policyholder.
from our bar, so he can't very well continue to represent clients once we've removed him from our bar.
And the church is grateful for that. My point is that that's an exceptional circumstance in this case, and it's not as if the client was unhappy with his performance.
But there's not the exceptional circumstances requirement for plain error review in a civil case, which is extraordinarily rare, very rarely granted. That requirement doesn't. It focuses on the nature of the error below, and the error below is a garden variety mistake by a lawyer not to advance the best argument and back it up with law and facts. He instead advanced other arguments that were no good. There's nothing exceptional about that. That happens every day.
Your Honor, I think that the error below is broader than just his error. That the evidence and the issues that were presented included this discussion about delay. The whole grounds of the summary judgment order is that the church was to blame for those delays. The evidence that was presented on that issue shows that there is at least a dispute of fact.
So
about
what
that.
was the error then?
The court's error was that it. I mean,
You can't very well ascribe any error to the court, and that's what plain error review in the criminal context focuses on. There was some misfire in the proceedings below by the court, usually, typically a miscalculation of the sentencing guidelines range or something of that nature that is very clear and very obvious and very clearly favors the defendant in the case, who's usually advancing these arguments, and should have been noticed by everyone, including the district judge, and that warrants a favorable exercise of this court's discretion because substantial rights are affected and the fairness and integrity of the proceeding are affected. And none of that is in play here. I don't even see a clear articulation of error, much less an argument that the error was plain and obvious. much less that it satisfies our exceptional circumstances requirement for plain error review in a civil case.
The evidence was presented. The core issue in summary judgment was who is to blame for the delay, and the court had everything in front of it. It could have if it had just been pointed to a page number.
The court should have gone and researched the issue and found the Pertel and Macoa cases that you're relying on here, and should have decided the novel question of law that they present under this prevention doctrine that you're advancing, and should have done all of that legal heavy lifting because counsel did not.
No, Your Honor.
I mean, that's what you're asking us to say. That's what plain error review necessarily entails.
This appeal would have been presented de novo, but for this, lack of a sentence or a paragraph in Mr. Smith's briefing. The core question is not about the prevention doctrine points toward the core question, and that is it reasonable for a policyholder in the church's position to wait for
and that's not a slam
dispute to be-
dunk on this record. So we can hardly call that a plain error.
We're not suggesting that summary judgment should have been granted for the church. It's just that there is a reasonableness is a fact question that a jury should decide, and that there is evidence in the record that supports that. The parties go back and forth, and the insurance company was responsible for almost all of the delay. And
What's the limiting principle on your argument here, to get back to Judge Hamilton's question? If we grant relief here, then it opens the door to plain error review in civil cases in any case where the lawyer made a mistaken judgment about which arguments to advance.
so I began at the court's broad discretion, and
That's not a limiting principle.
I
I'm
understand.
asking for a limiting principle.
But every time the court considers this that I've seen, it emphasizes that this is a case-by-case analysis. And
So
I
we
think
know
that's
it when we
important.
see it.
That is a part of this. I think that there are unique or distinct characteristics to the case. For example, that we were almost there. The below again. We're a sentence or a citation or a paragraph short of actually making sure that the district court was aware that reasonableness is disputable. Reasonableness of the delay. So
This isn't a case of payment or non-payment. Your client was paid a substantial sum.
that's right. That's right.
And what the record is shifting with regard to the difference between actual costs and replacement costs. What is that now?
I understand your confusion because it is not clear. I think that right now it's between $675 and $780 or $90,000. I think that if remanded, we would probably be at the limit of the policy by now due to the further delays. We were close to that on our replacement cost already. The insurance company had paid $1.5 million, and we were at around $2.2 million, and the limit is a little north of $2.3 million. So,
Mr. Tatum,
Yes.
I've got a question that may sound uninformed and naive, but do we have a ripe breach of the policy at this point under anybody's version of this? And I'll tell you what prompts that. I don't believe your client ever submitted a sworn complete proof of loss, did they?
yes. There are two proofs of loss.
Are they complete?
One, yes. Well, one is complete, and that's not disputed.
When was that?
That was, I think, in the fall of 2019. It's in our briefing, and that was part of the basis for the $1.5 million paid on actual cost value, And then the second proof of loss happened in November of 2019. And that's the one that the insurance company disputed and did not accept. It was a sworn proof of loss. The insurance company said that it wanted an actual cost value on that proof of loss as well as a replacement cost value. That was the main reason it rejected it. But there's not a dispute here.
Okay,
over,
you're satisfied there's a ripe breach of the policy from
Yes.
your client's point of view
Yes.
in failing to pay your claim for replacement cost.
Yes, at the very least, in the delays in closing the claim. I mean,
Has the claim in fact been closed?
no. In April.
And that's why that's my question in
Right.
essence here. Okay.
Okay.
You guys had to file suit. I understand that because of the way too coy response to the request about a tolling agreement. And I'll want to ask your opposing counsel about that. But if this hasn't been closed, what are we doing here at this point?
Well, I suppose the breach is all of these delays. I mean, we took 2 years and we still hadn't gotten to
Okay.
a point. We were at the point of appraisal, but we didn't have sufficient time to. But there was clearly dragging of feet and multiple delays, treatment to my client's detriment, and I think a breach of the insurer's duty of good faith. And so at the very least, those are the delay. And then there's an anticipatory breach here by the time that the lawsuit is filed for the same reasons. If there are no further questions, I'll reserve my time. Thank you.
Thank you. Ms. Rowe.
Thank you, Your Honor. May it please the court. The first thing I'd like to go back to is Judge Hamilton's question about the tolling response from Church Mutual, my client. I don't believe that was a coy response, not that that is relevant here. All that was happened is we were asked, at least all this in the record, and I will tell you, I do appellate work, so I'm also new to this case as my.
That's not really a very helpful response for us.
Right, but
We expect you to know the case.
I know the record. And in the record, what is in there is it says they ask us about a tolling arrangement, and they're talking about the suit clause, the 2-year suit clause, and not the 180 days. And they ask about the tolling arrangement, and all we say in response is, could you give us essentially a draft of what you're wanting us to agree to? Again, at this point, we're dealing with, Church Mutual is dealing with not a novice person. They have.
What is the purpose of this tolling agreement?
Well, they wanted to know the scope of it. What are they looking for? I mean, we didn't know the claims they were raising. The case was not closed out. We had not said anything in terms of, and at that point, we had paid the last check. They still had the 180 days. The way this works is once a check is made for the actual cash value, we give that advisement. It has to be done in a reasonable time. We give the advisement that says you have 180 days, or let us know if you have a problem with that. And they filed suit within 3 months of that, and alleged that we had breached. When the 6 month rolled around, that 108 days period rolled around, which would have been September of 2020, they hadn't done any. We hadn't.
That would have been
notified of
past
any repairs.
past the 2 years for suit.
Right, but this is a common practice. They will file suit, and then
Oh.
they will. Typically, what they would do is ask for an appraisal, because the whole issue in this was not coverage; it was valuation, and that would have been binding. It's almost like an arbitration proceeding. It would have been a binding process. And typically, what insurers do, if they run up on that suit clause, they will file suit, and in the complaint will say, you know, we request appraisal under the policy, and it stayed until they do the appraisal, which should have eliminated everything because it would have been binding on us. There was no coverage problem. There's no way we would have been bound by whatever that appraisal, the 3 appraisal process said. The umpire appraisal, would have weighed in if there was a conflict between the two appraisals, and we would have been bound by that. And that's not what happened. They asked for an appraisal, we gave a name. And, you know, they keep talking about all these delays from Church Mutual. I don't know what delays they're talking about. I've done an entire timeline of the record, of what's in the record. And to me, this is an illustration of good faith. In fact, I thought that's why they had abandoned the bad faith claim.
What, as I understand it, what they're talking about is your client taking months and months and months, a year and a half after the fire, there was no definitive position taken by your client. You were reserving the rights to, you didn't want them to start demolition to be able to start reconstruction, right?
No. What happened was, and the reason the timeline is the way it is we hired a building consultant, an outside person. They did the estimate. Lighthouse Tabernacle didn't like that estimate. Their guy comes back with a very huge estimate. We say, okay, once they had stuff in there, we changed it. We revised that as our estimate, our first estimate, twice, based on new things that had come to light. In one of their estimates that they had given was about, because the whole issue revolved around those glue lamb beams. And one of the things that they had said is, here's what we believe it's going to cost for these glue lamb beams to be put back up the way they were supposed to be. But it is completely subject to us hiring an architect and an engineer. So once they continued to complain, we hired an engineer. That's what they told us they were going to do. So we just went ahead and hired a third-party engineer. And then when they started asking the questions, like this all happened in November of 2019, they say, hey, they know about the engineer. And they're like, we talked about it. Where's the engineer's report? We're like, we're looking into it. The guy had been on vacation, and it was Thanksgiving. So we go past that. Then they say we want to demolish. And our response was, we have to have the engineer report. It wasn't that we have to have all investigation ever complete. There's no way the engineer can do a job, can do its report if the building is demolished. So we simply said, we have to have the engineer report. Once we received the engineer report, we gave it to them promptly. And that was it. And then after that is when we paid the final payment, like 3 or 4 months later, and it had that same 180-day clause that says you need to do this within 180 days or notify us if you can't. We never said, oh, we're still investigating. I mean, all we were waiting on is that engineer report. They have blown that totally out of proportion. If you read the emails, and they're in the record at Appendix 919 and 864, is the email that their public adjuster wrote to the pastor. And if there's any dispute at all, it became in that email. But that was not from us. That was from the public adjuster. And again, that's appendix at 864. But if you look at those emails, that's all we were talking about is the engineer report. And us getting that before we were able to, they would have to demolish at their own risk, essentially, is what we were telling them. Because we have to have the engineer's report. That's the whole reason we did this. And then they asked for an appraisal, which again would have resolved everything. We immediately gave them a name of our appraisal. That's how that process works. And then they give the name of theirs. Those two pick an umpire. And then those three determine the valuation of this property. And then that's how we would have been bound by that. Because again, there was no coverage dispute here. We knew that this fire loss was caused by an accident. We never said it was intentionally caused or anything like that. There was no coverage dispute. The only dispute was on the value of the property itself.
And the district judge was supposed to figure all of this out by herself and notice the error by counsel and do the research
And that's the reason,
in order to avoid getting reversed.
Absolutely. I mean,
this discussion about the merits presupposes that there's grounds to apply the plain error doctrine, rarely applied in civil cases.
I 100% agree, and I also believe that the plain error standard doesn't even come into play because the word, and I know that the case law has said forfeiture and waiver are used interchangeably sometimes, but in this case I believe it was used properly because even under their argument, he did not just not file a, when I say he, I'm talking about Attorney Smith, he didn't just not file a response. He did file a response. He filed a 9-page response. He filed designations of evidence. All the stuff they're relying on, he filed, or they're saying we filed. And he chose certain arguments to raise. Those arguments, admittedly, were not good arguments. But that happens all the time. And a new counsel will see a case differently and say, I mean, that happens when we come into cases on appeal sometimes. You look at it and say, man, I wish this argument had been raised, or whatever. That's just what happens. It does not, it's
The
not
court
plain
sometimes
error.
has that view too.
Yes. And if it's waiver, the plain error standard does not come into play. And so I don't think we can just cavalierly say, oh, well, waiver and forfeiture are always different. This is definitely a forfeiture because even though they raised 5 arguments, they missed the one argument that was a good argument. Every litigant can say that when they lose. All they have to do is get new counsel and say, hey, you know, I lost. There had to be a reason. It couldn't have just been because my claim wasn't good. It had to have been because the arguments weren't raised properly. And so we believe the plain error standard doesn't even come into play. If it does come into play, there are no exceptional circumstances here. And I can talk about that, but I believe that has already been discussed. I don't want to waste this court's time, and it's certainly briefed. But this is just a simple case of, you know, at this point, they lost at the district court level, and they believe it was their attorney's fault. But at that time, their attorney was in good standing in all the courts it was before. I'm not saying it was a great attorney. I don't know. I'm not impugning the attorney either. I don't know this attorney. I'm simply saying the attorney was in good standing, and it's the attorney they choose that they had chosen. They could have chosen any attorney they wanted. That's who they chose. And when you do that, that's your representative, and they're limited to that. We also believe there was no prejudice here, because we don't believe at the time that the only argument they keep in the briefs, they keep talking about how Church Mutual denied the claim. They never denied the claim. You know, a lot of times you'll see an insurance company will say in a written letter, in a form letter, you know, we deny this claim for X, Y, and Z. That was never done here. What they're using is in the summary judgment motion, which was almost a year after that last 180-day deadline had expired. And in that summary judgment motion, we were saying, look, they filed suit against us for breach of contract. They have not identified the breach. So we were kind of blindly shooting out and saying, we didn't breach because of the actual cash value. We paid everything in the actual cash value that we were supposed to pay from your first proof of loss. Your second proof of loss was rejected. And you never gave us another one. And so we didn't do that. And then we had another reason. We didn't breach because of, you know, we didn't breach because not paying the replacement cost value, because in order to get replacement cost value, you absolutely have to repair within a reasonable time. And what we were using was not the reasonable time from the date of loss. What we were using is a reasonable time from that March 24th, 2020 last check when that was paid. And at that point, again, I'm talking by the time the summary judgment was filed, it was a year and a half after what that 180-day time period would have expired. And so at that point, we said, look, there's no breach there. And so even if they had raised a different argument, there was too much time had passed. They'd never told us, and they'd never identified, they'd never told us they had made repairs, we're making repairs, we're starting repairs, nor did they tell us, look, we have a problem, we don't have sufficient funds, or whatever, and we're going to have, you know, we need something else. So if there's no other questions, I thank you, Your Honors.
First, Judge Hamilton, I wanted to answer your question. The first proof of loss was in November 2018. That's on Appendix 860. I want to correct something that has been confused in the communications, beginning with the communications between the parties and in the briefing even. And that is that the standard here is not 180 days. It is a reasonable time to rebuild. The 180-day reference, it seems to me, comes from the requirement to notify the intent to pursue replacement cost within 180 days of the loss. But that 180-day language is not within the repair or replace as soon as reasonably possible, as that is the phrase that's in the policy. And you can see that on Appendix 439.
Why wasn't this argument waived instead of merely forfeited? Your whole avenue to appellate review at all depends on there not being a waiver.
You know, Church Mutual has not pointed to any evidence that it was a strategic decision. It
There
was a
doesn't need to
knowing
be
or-
any evidence of that.
Well, it
This
needs
is
to
a
be
judgment call on the part of the court, and the distinction between waiver and forfeiture in civil cases is not as well defined as it is in criminal cases. There were no rights that were at issue here. This was just a judgment call by counsel on which arguments to advance, and the selection of some and exclusion of others is ordinarily a strategic decision by counsel. What is there that indicates that that general rule does not apply here?
The briefing below includes a sentence or two talking about Church Mutual's delay. It is not. It doesn't point to any evidence. That
Right,
was
it's
what the
just
district court.
He didn't emphasize that argument and back it up in a robust way. He made other arguments. That's a judgment call by counsel. That's a strategic decision by counsel, and the risk of a bad decision falls on the client, not on the opponent.
Your Honor, I would encourage you to read the summary judgment brief that he filed and to decide for yourself whether you think that was a strategic decision.
Just because it was a bad decision doesn't mean that judgment wasn't exercised. He made a decision about what arguments to advance,
Yes.
and that's a judgment by counsel.
I-
It's just because it's a bad decision. If every bad decision by an attorney in a civil summary judgment filing
The
is
evidence
a
below,
forfeiture instead of a waiver and grounds for plain error review, there is no limit to plain error review.
I think that a waiver does need to be knowing and intentional, and this court can judge for itself whether it thinks that the church knowingly and intentionally waived that argument. The dispute is evident in the record, and that was before the district court, and summary judgment should not have been granted. Thank you.
Thank you.
All right, thank you. Our thanks to both counsel. The case is taken under advisement. We'll move to our third case this morning, Bert Ford versus Dennis Regal. Ms. Cleary.
Thank you, Your Honor, and may it please the court. My name is Elaine Cleary, and I'll be giving the opening, respectfully reserving 2 minutes for rebuttal by co-counsel Samantha Riley. We are alongside co-counsel Patrick Hecker, and together we represent the petitioner, Mr. Bert Ford. Your Honor, this case is about whether an attorney who does even less for his client than precedent requires provides constitutionally ineffective assistance of counsel. The law makes clear that a defendant's Sixth Amendment right to counsel extends to the plea bargaining process. The Supreme Court expressly held in Lafler v. Cooper that defendants are entitled to effective assistance of competent counsel during plea negotiations. Negotiating a plea but failing to provide proper advice, and negotiating a plea but failing to communicate it to the defendant are ineffective. It must therefore also be the case that declining to negotiate a plea altogether is also ineffective.
Well, this case does represent an extension of the principles announced in Missouri v. Fry and Lafler v. Cooper, and we don't usually extend the law on habeas. The principle relied upon must be clearly established, and it would represent, in this case, an extension of Lafler and Fry to extend that plea bargaining ineffectiveness analysis to what happened here.
Your Honor,
There was no plea offer on the table, is the bottom line. So there was no failure to communicate it, and there was no failure to give effective advice regarding whether to accept it, because no plea bargaining had happened yet, and there was no offer.
Correct. No plea bargaining happened because after the prosecutor offered to negotiate and Mr. Ford instructed his attorney to negotiate, Mr. Hicks, the attorney, ignored his client's instruction and did not negotiate. Mr. Ford was forced to proceed to trial where he received a 70-year sentence.
Understood. So it's
Yes.
an extension of those cases, not an application of those cases.
I
And
think
so
it is-
it doesn't satisfy the clearly established requirement for habeas relief.
I think there are two parts to your question, Your Honor. So first, we are seeking de novo review because per the law of this circuit in Courtroom v. Neal, when the state court decision, here the Indiana Court of Appeals opinion, which the state does not dispute, was the last reasoned opinion in this case, fails 2254 D1 and D2, which here it did, de novo review applies. But to your other points, this is not an extension of Lafleur and Fry, but merely the only reasonable application of those precedents to this case. And the 6th, 11th, and 8th circuits have held so in Byrd, in Hockman, and in Carmichael. It doesn't make sense, Your Honor, that an attorney is ineffective when he or she negotiates a plea but fails to communicate it, but not ineffective for failing to negotiate a plea altogether. An attorney like Mr. Hicks, who does even less for his client than the ineffective attorneys in Fry, in Lafleur, and Padilla, should not be more deserving of constitutional protections than an attorney who does more.
And that may be correct, Ms. Cleary, with regard to syllogistic logic, but we have to look at the law, and there's not a case that says that, and that's the problem.
I think that Hill v. Lockhart says that. So Hill v. Lockhart is a case that goes way back to 1986 from the Supreme Court, and that was the case that said that Strickland versus Washington applies to plea bargaining. Defendants have Sixth Amendment rights in the plea bargaining process. And what Lafleur and Fry did, and Padilla in 2010, 2 years earlier, was to take that principle, that general principle from Hill, applying the principle from Strickland, and to apply that principle in a fact-specific context. So I think Lafleur and Fry are specific applications of the Strickland principle, the Hill principle, to the facts before them. And I think it's important to note that the Supreme Court in Lafleur and Fry said expressly on page 162 of Lafleur, defendants have Sixth Amendment rights in plea negotiations. Defendants have Sixth Amendment rights in the plea bargaining process. The Supreme Court says nowhere in Lafleur or in Fry that its holdings are limited to formal pleas. Yes, the facts of those cases involved formal pleas, but I think we see, especially together with Padilla, that those cases were applications of the general principle that defendants have Sixth Amendment rights in the plea bargaining process, again, quoting page 162 of Lafleur versus Cooper.
We may keep you up a little longer than usual because this is a complicated case. Timeline, trial in 2005, we begin to get this habeas activity in 2018 to 2020. Is there anything in the record, or do you know, under Indiana law, whether it was Mr. Ford's obligation to transform this post-conviction circumstance into this affidavit format, or was that the court's obligation to do that?
I'm not sure I totally understand the question, Your Honor. My understanding is that Mr. Ford filed his first appeal in 2007 after his 2005 trial. The state took no further action on that appeal until 2018.
And what I'm getting at is that 11-year gap. Whose obligation was that to get that decision made? Was it the court's obligation? Was it Mr. Ford's obligation? Was it a former attorney's obligation? I'm trying to discern why the gap.
I believe it was the state's obligation. Mr. Ford did everything in his power to move the appeal forward. It was not Mr. Ford's negligence that caused the delay. I'm not sure why exactly the state delayed the process of the case for 11 years, but Mr. Ford had filed his appeal in 2007 and was received by the court. I don't know why there was a delay on the part of the state of Indiana.
Ms. Cleary? Oh,
Yes.
sorry.
Okay.
Could I ask you a couple of related questions here? Triggered by a comment in your brief at page 56, you say, Mr. Ford has demonstrated a reasonable probability he would have accepted the plea. My question, one question is, what plea? Since we don't have anything ever put on the table here. And the broader question is, if we were to agree with you and remand this for at least a hearing, what would that hearing look like? Going back almost 20 years, trying to figure out what would the state have offered this sounds like just an impossible task at this early, where you're saying the failure occurred before any negotiations even took place.
Yes. So Mr. Ford, per page 129 of the appendix, requested that Mr. Hicks go and see what kind of deal the prosecutor would offer after the prosecutor had already offered to negotiate.
I understand that.
Yes. So 97% of state defendants in Indiana received
I understand
pleas.
that too. What's the, I mean, but we never got anywhere in this case. There's no, how would you even go about identifying what should have been on the table if he had asked?
Sure. I think there are two parts to your question. So first, I think an evidentiary hearing would allow Mr. Ford to finally gain clarity on these issues that he has been pursuing for 16 years. So was there any strategic justification for his attorney's decision to ignore his request to plea bargain, to proceed to trial?
Let's assume we agree this was deficient performance in failing to follow up. But in essence, how would you go about proving prejudice? What is the plea he says he would have accepted 20 years ago?
It is extremely likely, per statistical evidence that we cite in our brief, that Mr. Hicks would have received a plea. It's also likely that he would have received a plea that was less than the 70-year sentence he received at trial. And we know that that kind of sentencing disparity, so he received a sentence at trial that was 10 times longer than the average sentence.
There were a lot of aggravating circumstances here, however, correct?
Yes. But a 70-year sentence for rape is still extreme, an anomaly, at least per the cases that we looked at in Indiana.
But we're talking, though, about trying to reconstruct what a voluntary agreement between two parties might have been, subject to approval of a trial judge, right? Mm-hmm. How do we go about identifying terms? Were there policies in place in the prosecutor's office in Allen County at that time about pleas? Do we have any idea?
I think an evidentiary hearing would help bear out these issues. So Mr. Ford has sought diligently for 16 years to answer these very questions. Why didn't Mr. Hicks take him up on his instructions of plea? I think if there were an evidentiary hearing, Mr. Ford could subpoena the prosecutor, he could subpoena his attorney, and we could finally get answers to questions that you're asking about what the plea would have been and whether it would have been less than the 70 years he received. I think there's data, though, from our analysis of similarly positioned defendants in Indiana and national sentencing statistics for state convictions that any plea for these crimes would have been less than 70 years.
And what reason do we have to expect that Mr. Ford would have accepted such a plea at the time without using 20/20 hindsight after knowing what his ultimate sentence was?
So, Mr.
What
Ford...
we have that I've seen so far is simply he asked the lawyer to find out what the state was going to offer.
Judge Hamilton, that is the standard under Strickland. So Strickland, and as articulated again in Lafleur, say that a defendant can establish prejudice when he can show a reasonable probability that but for his attorney's unprofessional conduct, the outcome would have been different. And we know from case law...
You're not following my question. Ford has to prove he would have accepted the plea. Not that the plea likely would have been better than 70 years in prison. That's the blinder of hindsight that we have here. We have to go back to that ex ante position, and he has to prove that he would have accepted some unspecified plea that we're trying to reconstruct 20 years later. This is a proof problem that just sounds nearly impossible to me. And I'm looking for some guidance as to what we might ask a district court to do if we were to send it back.
Sure. Well, I think we have standards from case law that help bear out this reasonable probability standard. So he just has to show a reasonable probability that the outcome would have been different, that he would have gotten and accepted a plea. And this court said...
How does he do that? He has no contemporary evidence other than he wanted to know what the state was going to offer.
Well, Your Honor, other courts that have looked at this exact issue have held that that's sufficient. So the D.C. Circuit in Knight said that when a defendant asks his attorney to go and see what the prosecution will offer, that's sufficient to establish a reasonable probability that he would have accepted a plea. The Second
How
Circuit
does
said
that make any sense?
this is what the courts have said in Fulton and in Knight in the Second and the D.C. circuits respectively. I think it does make sense. I think Mr. Ford was facing serious charges. He had no guarantee of acquittal at trial. It's very likely that he would have accepted a plea had one been offered, and it's likely that plea would have been more favorable than the the sentence he received at trial. And what's more, the law of the circuit in U.S. Ex Rel. Hampton versus Liebach has said that to meet this reasonable probability standard, a defendant does not need to show with certainty that the outcome would have been different. With certainty, Judge Hamilton, that he would have accepted a plea. He needs only show that his chances of acquittal were better than negligible, and here they were.
No, that better than negligible language is not a legal standard. The legal standard is a reasonable probability.
Yes, I think that language is helpful in understanding the issues.
It's not a legal standard. It should not be referred to as a legal standard. The legal standard from Strickland is reasonable probability.
Judge Sykes, I think Mr. Ford meets that reasonable probability standard here by asking his attorney to go and see what the prosecution had to offer. The only reason he had no plea to accept is because Mr. Hicks did not even take the call to negotiate a plea. I mean, it's very unlikely that he would have been in the 3% of criminal cases in Indiana that did not end in pleas. The overwhelming likelihood is that had his attorney taken the meeting, he would have at least received an offer.
So far, you've been discussing this case on the merits as if we're under de novo review, which
Yes.
is the second tier analysis, because EDPA deference is the starting point, and you have to demonstrate that the Court of Appeals of Indiana unreasonably applied clearly established federal law as determined by the Supreme Court, or made an unreasonable determination of the facts. And I haven't heard any argument on that yet, so that's your first line of argument.
Yes, so the Indiana Court of Appeals misapplied clearly established federal law by incorrectly applying the missing evidence rule.
That's not a rule of federal law that applies to the states through the Supremacy Clause, so that argument is a non-starter, complete non-starter.
Even if
the state court applied its own missing witness rule that appears to be in place for post-conviction motions or petitions. So it's a rule of state evidence law. There was no federal evidentiary rule applied. There is none that applies in state court proceedings.
Well, even if this court does not accept the D1 argument, the Indiana Court of Appeals decision was still based on an unreasonable determination of the facts.
Well, that assumes that there were factual determinations made here, and what the decision rests on is not determinations of fact-finding in the ordinary sense, but factual deficiencies. The appellate court found the record deficient to support Mr. Ford's arguments, both on the plea bargaining issue and the other issues in the case, because all he had was his own affidavit. He had nothing else.
This court has said, Your Honor, in Dalton, that a defendant's affidavit can be sufficient to support the kinds of factual findings that this court should have been making, but the state court refused to consider.
We're talking about sufficiency under state law. We don't apply federal sufficiency standards when we're reviewing under EDPA deference state court judgments.
Well, the Indiana Court of Appeals did misapply clearly established federal law. That is our position, that its application of
I know that
reverse-
that's your position. I'm
Sure.
suggesting that that's a weak one, and your argument about an unreasonable determination of the facts struggles because there really were no determination of facts here. There was a judgment by the appellate court, which is the last court to review this on the merits, that there were factual deficiencies, so the claim failed for that reason, because the only thing in the record was Mr. Ford's affidavit. There was no evidence, affidavit, or otherwise from the defense lawyer.
I think the Indiana Court of Appeals did make factual determinations. So they did determine that there was not ineffective assistance at plea bargaining without holding an
That's a
evidentiary
legal
hearing.
question.
I thought your position was that Mr. Ford did all he could to try to get an evidentiary hearing in the state courts and didn't get it.
He was denied an evidentiary hearing. The Indiana Court of Appeals then refused to consider the fact that he had attempted to procure his attorney's testimony through informal correspondence, via certified mail, through deposition, through compelling testimony, and by seeking an evidentiary hearing. And he was thwarted at all turns, first by his attorney and then by the Indiana state courts, who denied his motions. So the Indiana Court of Appeals here made a factual determination without allowing Mr. Ford to sufficiently supplement the record.
There was no factual determination here. There was a determination that the evidence was insufficient to support his claim.
The factual
He apparently tried, after 10 years of being represented by counsel and counsel's withdrawing, and we don't know what happened in those 10 years. We don't know why his attorney didn't develop the Strickland claim. The record is silent on all of that. There's no direct challenge to Judge Brennan's question to the procedure that was used here, the state procedure, which permits the court to require submission of the case on the affidavits, such as they were. There was only one. Nor would there be a valid challenge to that, it seems to me, on habeas review. That's a state procedure. So I'm not quite sure where the D2 argument goes here.
Well, we think that the Indiana Court of Appeals determination that there was insufficient evidence here was not taking into account the fact that Mr. Ford has attempted to supplement the record by obtaining his attorney's testimony through an evidentiary hearing. He would surely also have been able to obtain testimony from the prosecutor.
Right, but we don't correct procedural errors under state law by state courts on federal habeas review.
We maintain that the Indiana Court of Appeals fails 2254 D2. And therefore, this court does have jurisdiction over to correct that court's mistakes. That court made
What's the federal rule that was violated? Or is, what is the hook there? This was a procedural misstep, I think your argument is, by the state appellate court based on this affidavit procedure, apparently, but that's a matter of state procedural law.
The Indiana Court of Appeals violated 2254 D2, the statute, and there is federal law. There's guidance from the Supreme Court in Brumfeld and Miller L. that the state court must take account of the evidence before it. I mean, this circuit has said in Lee versus Kink, a state court cannot insulate its decision from review by refusing to entertain vital evidence. And here, in refusing to allow Mr. Ford to supplement the record with his attorney's testimony while simultaneously holding that Mr. Ford had provided insufficient information, insufficient evidence to substantiate a finding of ineffective assistance of counsel, this court fails those standards from Brumfeld, from Miller L., and its decision was ultimately based on an unreasonable determination of the facts under 2254 D2.
Okay, thank you very much.
Thank you.
We'll hear now from Mr. Colby.
May it please the court. Petitioner did not allege or establish sufficient facts in the state court to entitle him to relief. The conclusion that petitioner failed to establish his claim was a reasonable application of Strickland. Petitioner's unreasonable determination of facts claim also goes nowhere.
Why, Mr. Colby, isn't this similar to the Lee versus Kink case, where affidavit comes in, we're unable to determine the universe of the charges, and then that case gets remanded for an evidentiary hearing to find out whether or not there were plea negotiations, to find out what those plea negotiations might have looked like?
A couple answers to that. First of all, even taking what the petitioner alleged here in his affidavit is true before the state court, that's not sufficient. So even if he had an evidentiary hearing to establish everything he said in his affidavit, that he just was interested in seeing what the state had to say.
He wants much more of a hearing than that he was not able to develop because the state courts would not let him. I share Mr. I share the interest in Lee against Kink, which petitioner relies upon and you did not mention in your brief.
Well, I think that the first answer to that is the suggestion that the state court prevented the defendant from presenting, or the petitioner here from presenting evidence, is not true. He could present anything he wanted in his affidavit, and he could present.
No, he needed to get evidence from his attorney, and from a prosecuting attorney probably as well.
And he wasn't prevented from doing either of those things. He could have done either of those things. He could have asked for discovery
He
from
tried.
the state.
What did he do wrong?
The first thing he did, he said he wanted to depose counsel, and the post-conviction court said, well, tell me what you want to ask counsel, and I'll decide whether we need to depose counsel. And he didn't respond to that, so the trial court never set the matter for deposition. Then he said, I want you to order my counsel to provide affidavits. And the trial court said, well, what are the affidavits you want them to, have you provided them with the affidavits? There's no evidence that there's evidence that you've corresponded with them, but there's no evidence that you've asked them to sign affidavits. Provide that evidence and then we'll go forward. Even the trial court then said, I'll look at your affidavit, and if your affidavit shows that we need to have a hearing, then I'll hold a hearing, or I'll...
So just so that I understand, your position is that the trial court and the state court was receptive to holding a hearing, but that petitioner failed to respond to its questions.
Correct.
Okay.
Well, and what happened in the 10 years prior when Mr. Ford was represented by counsel in this post-conviction petition, as I understand the record, and didn't go anywhere with it? Do we know what happened?
No, we don't know what happened. The state public defender's office was first assigned to represent the petitioner here, and then after 3 years on the case, they withdrew. It's unclear. The normal practice is they withdraw after they evaluate the case, and they submit a memo to the defendant or the petitioner saying, we don't see anything here we can raise. If you want to go ahead and raise things yourself, you can, but we're not going to represent you any further.
And do we know one way or the other whether that occurred in this case?
We don't, because that wasn't developed. All we know is that the state public defender withdrew. We don't know what information they provided to the petitioner. Then he hired private counsel who represented him for a number of years. I think 2000, I forget when he entered his appearance, but he got off the case about 2018, and then it went, the petitioner represented himself. And there's no indication there why.
So he had ample opportunity over the course of more than a decade to develop an evidentiary record for a Strickland claim.
Yes.
And so it wasn't any fault of the court or any obstruction by the court or any acts by the court preventing him from doing that. In fact, the case remained open for a very long time.
Correct.
Through two lawyers.
Correct. And we have no evidence in the record of what the petitioner knew. What evidence did he have defense counsel's file and all his notes? There's just nothing.
So this is not at all like Lee versus King.
No. This is not a case in which petitioner he could have alleged in his affidavit. I mean, even if there was some barrier to him getting information from trial counsel, he could have alleged in his affidavit that he heard that there was an offer, what the offer was, or indicated anything about his willingness to plead guilty. But all the contemporaneous evidence, and even his affidavit, indicates he would not plead guilty. He asked for a speedy trial, which within 70 days of his initial hearing. He went to trial, and then at sentencing, the first thing out of his mouth to the trial court was, let me make clear, I am innocent of these charges. Nowhere in the record, anywhere, has it ever been suggested by him that he would plead guilty. And that was the basis of the post-conviction court, and then the Court of Appeals saying he hasn't presented any evidence to say that conclusion was wrong, because the only thing he presents is his curiosity as to what the state may have been willing to present as a plea offer. And I would point out that Judge Hamilton, going back and trying to recreate this is very difficult because of what happened at trial. He was acquitted of one of the rape charges and one of the misdemeanors at trial, and then he received the advisory sentence. The suggestion, it would just be pure speculation that any offer from the state would be any better than what he received actually at trial of dismissing a count and an advisory sentence.
We don't know, right?
Right.
Allen County is a big county. big prosecutor's office. I assume individual prosecutors then and now are not free to do what they want to do on making deals. There might have been policies in place.
Well, especially on A felonies that the defendant was minimum non-suspendable on. So he was facing at least 20 years on the Class A felonies. So the suggestion that the state would offer something well below the non-suspendable portion of the sentences is pure speculation and unlikely to occur. I mean, the prosecutor's just not going to offer.
Does this case date back to the days of one for one good time?
It does, Your Honor. So he will serve 35 years. And I would just point out the data that the appellant's brief cites to is actually the amount of time in which a person is first released from custody, not his sentence. So what it says is first released on parole or probation. So an average of 7 years in Indiana in 2005, that would have meant a 14-year sentence, assuming good time credit, that then a person's released on probation or parole. So again, there's just no evidence that there would be a huge sentencing disparity between any speculative offer and what he received at trial.
So from Mr. Ford's perspective, would he have had available to him this Davis-Hatton procedure under Indiana law where he could have suspended his direct appeal and created some kind of record with regard to the law with his lawyer?
He could have, but he basically did that because he sought post-conviction directly after his direct appeal. Okay. His direct appeal was over in 2006, and in 2007 he filed his petition for post-conviction relief. So there wasn't a lot of that would have saved him maybe a little bit of time. Well, maybe not. Maybe it wouldn't. Maybe if he would have done that, his direct appeal wouldn't have been decided for several years while it meandered through post-conviction.
Mr. Kobe, the petitioner, as I understand it, is telling us that the state did offer to discuss a plea and that he told his attorney to do so. Do you agree we have to treat those 2 points as true for purposes of this appeal?
I don't believe so, because I don't believe that the state court found that to be true. What the state court said was, we don't believe that you wanted to negotiate because everything about this trial was you asserting your innocence. And so the trial court said there was no suggestion that you ever wanted to plead guilty. So I don't believe that you were, whether it's sincere in asking for an offer or I don't believe you ever asked for an offer.
That's what the post-conviction court said. The Court of Appeals rested its ruling on different grounds, did it not, on the plea bargaining claim?
I don't believe so. I believe the standard review in post-conviction for the appellate court is that the post-conviction court was wrong. And so what the Court of Appeals said was, you don't have any evidence to show what the what the post-conviction court said was wrong. All you have is your affidavit, and the post-conviction court didn't have to believe that, and there's no other evidence that shows that the post-conviction court was wrong, so we affirm.
Failure of proof, basically.
Correct. Okay. I'll just point out, this would be an extension of Lafleur and Fry. Even this court hasn't accepted that extension in 2255 cases. So this court has recognized that without an offer, you can't make out a claim under Lafleur or Fry. So this would be an extension. And it's what the Court of Appeals did was not unreasonable application of Strickland or Fry or Lafleur application of Strickland.
Do you think an attorney provides sufficient performance if the client asks to solicit an offer from the prosecutor and the attorney refuses?
I think that's too broad of a statement, because I think there could be information in the attorney's knowledge that would indicate that would be pointless, or what the defendant asked for. Go ask the state if they will give me a plea to no jail time, and the attorney says there's no reason to take that.
I'm not. We don't have that here. What we just have is, what are they offering, right?
I think that
how is that sufficient performance by an attorney? I understand there are very difficult problems about proving prejudice.
I think without more, that wouldn't be sufficient to establish a violation, and definitely wouldn't be something that the state court would have to find deficient performance in that situation under the U.S. Supreme Court case law jurisprudence. Could it be sufficient for a court?
If
Yes,
I understand
maybe.
your answer, you are speculating that there might be excuses, in essence, for failing to follow that instruction.
Well, I think what I'm saying, maybe excuses, or just there may be reasonable reasons that counsel wouldn't follow that
But unless we know,
instruction. But of course, yes. But of course, it's the petitioner's burden to establish that he has been denied the ineffective assistance of counsel.
to establish that there was no possible explanation for it, how's he going to do that without getting the attorney under oath?
No, I think he has to do more than just say, I was interested in negotiations. He has to allege more than that, because he has to allege that he would have accepted an offer that was made and that he would have pled guilty and the court would have accepted it. And so just saying, I think I'd like to find out what the state's thinking is not enough to establish a Strickland claim.
Actually, wouldn't he have to do more than just allege those things?
Well, he'd have to
put in
provide proof.
admissible evidence in the form of a sworn statement that all those things were true.
Correct, Your Honor.
Thank you.
State asks that you affirm.
Ms. Riley.
Thank you, Your Honor. Just a couple of points in response to the government's argument. The first is that ignoring evidence is a D2 error. That has been found in Nunes by the Ninth Circuit, in Dalton by this circuit, and it has been affirmed with the reasoning of Miller L.V. Cockrell in the Supreme Court.
But the problem is that there was no evidence ignored here. It just wasn't in the record. This was an evidence deficiency problem, a failure of proof, rather than a court that was ignoring record evidence.
There was a determination or an inference that the evidence that was not presented by fault of Mr. Hicks would not have helped Mr. Ford. And that is the factual determination that was made.
Could you address, as specifically as possible, the state's point that the PCR court responded to Mr. Ford's request for a hearing, deposition, development of the evidence, and that he then failed to respond?
That Mr. Ford failed to respond?
Yes.
So what the record shows us is that Mr. Ford made repeated attempts to communicate with Mr. Hicks and to go through post-conviction court proceedings in order to supplement the record, and that he was thwarted at every turn. So his motions were denied.
My question, the state told us that the court directed requests for additional information to Mr. Ford. Is that correct?
Yes, they sought more information from Mr. Ford.
Did he respond?
He did not. He was not able to provide that evidence.
Why is that not a problem here?
It is a problem, but likely in a different way from how you're suggesting, because all of that evidence was in the power of Mr. Hicks to provide a justification for his actions and his deficiencies. So Mr. Ford, especially as a pro se litigant, did everything he could. He took every step available to him. He sought that information, and he was thwarted.
Do we have his responses in the record?
We do not.
Okay.
And so if I may turn to an earlier question of yours, Judge Hamilton, and specifically addressing the relief that is sought here, granting habeas relief would require either releasing the prisoner or retrying the prisoner, and no plea deal need be revitalized or resurrected, recreated. Instead, there would be new plea negotiations, there would be new appointment of counsel, and the trial would go on as needed. But even if this court still maintains doubts about a factual disparity or factual discrepancy, it should order an evidentiary hearing. And that evidentiary hearing could affirm that there was deficiency here, very much in line with the deficiency that was found in Fry in the Supreme Court. It may reveal more information about prejudice by compelling Mr. Hicks to comply, and that would be in line with other circuits' treatments of this. of this issue with plea bargaining. And so for the foregoing reasons, we ask that this court grant full habeas relief to Mr. Ford, or in the alternative, order an evidentiary hearing. Thank you.
Thank you very much. Ms. Riley and Ms. Cleary, you have the gratitude of the court, and your professor and your colleagues at Northwestern Law School have the gratitude of the court, and I see some of them probably in the gallery here today that probably worked on this case, so you also have the thanks of this court for your excellent advocacy in this case, your willingness to accept this difficult case and this appointment on behalf of your client. Well done. Thanks to all counsel. The case is taken under advisement. Our next case this morning is Calvin Choice versus Cohn Law Firm. Mr. Casano.
May it please the court, Mario Casalo on behalf of appellant Calvin Choice. I would like to reserve 3 minutes for rebuttal. This appeal stems from a dismissal of a case filed under the provisions of the FDCPA for lack of Article III standing. Specifically, plaintiff alleged that defendant's statement that an unspecified figure of statutory attorney fees are due and owing violates the FDCPA, since statutory attorney fees do not exist in Illinois in a debt collection lawsuit context.
Mr. Casala, I want to focus in on the First Amendment complaint, specifically juxtaposing paragraph, I think it's 64, with some of the paragraphs later, 76, 80, 81. What I'm wondering is whether those allegations are contradictory. Has Mr. Choice made an allegation that he decided to contest the debt even in the absence of the alleged misstatements about the attorney's fees?
Well, I think ultimately he went through the spectrum of beliefs. Because the collection complaint had inconsistent statements, he had inconsistent beliefs. He didn't know what was true. In other words, in one part of the complaint, there was a prayer for relief for statutory attorney fees. In another part of the complaint, the affidavit specifically, it states that no other charges are being sought. So he didn't know what to think.
So we know under Brunette that confusion is not enough. There's got to be some detrimental step.
Yes.
And the question would be, was he able to take a detrimental step if there's no concrete language as to what he would have done?
Well, he did allege very clearly that he would have resolved the debt. In other words, if he would have resolved the debt, he wouldn't have had to pay an appearance fee, he wouldn't have had to hire counsel, he wouldn't have had to expend time and energy in doing so. So that is the detrimental step, that is the harm. Had he been told the truth, that this is what he owes, and he doesn't owe some further unspecified amount, that would be it. He wouldn't have to spend extra money, which could have gone toward resolution of the debt.
Well, if that was clear, though, why? I mean, these aren't alternative pleadings. It's not as if the paragraph in the First Amendment complaint says, and in the alternative, he takes the opposite position. The First Amendment complaint is just unclear as to what Mr. Choice's position, any concrete language is as to what he would have done, and how the attorney's fees would have changed that.
Well, the attorney fees would have changed that because he didn't know how much he owed. And he thought he owed a lot more, which is ultimately, and that was one thing he believed, that's why he sought the advice of an attorney. He didn't know what to believe, ultimately. But for the actions of the defendants, but for them stating that statutory attorney fees were due, he would have resolved it. And I think he's alleged that. Even though he was also confused in a different manner regarding the other statements in the collection complaint. Like I said, there are 2 different versions in the collection complaint of what is owed. The affidavit says one thing, the 280.1 affidavit says one thing, and the prayer for relief says another. So I think he was reasonable in entertaining both and in coming to different conclusions based on either. With respect to plaintiff submits there was error for the district court to find that universally hiring an attorney cannot establish standing. This is because unlike the cases to which the court cites, plaintiff didn't just hire a lawyer merely to obtain an advisory opinion, for example, based on the letters in many of the cases decided by this court, like Pennell, I believe it was Smith, Basil, Spuler, Gunn. Rather, in this situation, he, faced with a lawsuit that he had to defend, hired an attorney to defend against this false claim, the spurious claim of attorney fees, which he believed were very substantial. Specifically, he hired and paid a lawyer to defend against a false claim of statutory attorney fees. And this is a distinction recognized by this court in the case of Crabtree versus Experian, where the court expressly noted that the cost to defend a lawsuit can be an injury in fact for purposes of Article 3 standing. The Seventh Circuit thus distinguished cases holding that a plaintiff may not satisfy standing by pointing to the cost of bringing suit, noting that the defendant had alleged that the harm is the cost of defending suit, not bringing it. And the court concluded that in Crabtree, in defending claims, the defendant has suffered a redressable injury in fact that is traceable to the plaintiff. As in Crabtree, plaintiff's alleged injury here is the cost of defending the lawsuit. Again, the attorney fees and the appearance fee. Specifically, he hired a lawyer to defend the action, which sought a sum certain plus attorney fees alleged to be owed in some unknown amount. The fees were not owed, however, and plaintiff alleges he would have resolved the debt had he known the truth, which is that he owed nothing in fees. He was thus injured financially by having to pay an appearance fee, by having to pay an attorney, due to defendant's misrepresentation as to those fees. And his injury was also individual and particularized to him. He was affected. He's the one who had to pay the money. And his claim is also plausible, since his allegations, if true, would have saved the money. And this is a reasonable path to take, and therefore a plausible one. Second, with respect to the appearance fee, the court erred in not even considering plaintiff's allegation in the amended complaint that he paid an appearance fee and was harmed thereby. So even assuming arguendo that attorney fees, hiring an attorney to defend against a false claim doesn't constitute concrete harm, plaintiff's payment of an appearance fee in a state collection action, which he alleged he wouldn't have paid had he known that the debt did not include attorney fees, does constitute a harm. And per Crabtree, again, and the other cases cited, an appearance fee is a cost he incurred that establishes an injury in fact, as it was only occurred as a result of defendant's misrepresentation. And he alleged he wouldn't have paid it had he known the truth. He alleged that he would have sought to resolve the debt. Now, the defendants take the position that saying resolving the debt is speculative. What does that mean? Well, it's clear what that means because this court considered that same scenario in Chulumbat, another Seventh Circuit case that was decided fairly recently involving fairly similar facts. There, the court noted that because general allegations in a complaint are presumed to embrace the specific facts necessary to support those allegations, in this case, him stating that he would have resolved the debt embraces the specific fact that he had the means to do so. So it wasn't speculative, his statement that he would have sought to resolve it. He would have done what was required to do, either pay the whole amount or if he was offered a lesser amount, he would have paid that. So that's a non-argument. And again, this is taken directly from the Chulumbat Seventh Circuit opinion entered not too long ago also on the issue of Article 3 standing. Moreover, the district court erred in finding that plaintiff's admission that he didn't suffer actual damages dooms his complaint. And I think a brief history is instructive here on the pleadings. Plaintiff originally filed his complaint before the slew of cases entered by this court regarding Article 3 standing. He alleged statutory damages only, and he responded to requests to admit. And in response to a request to admit, did you incur actual damages? He said no, and that was consistent with his pleading at the time. After this court entered a whole bunch of cases, I think it was Larkin, Bazile, Spuler, Gunn, et al., plaintiff told the court that he wanted to amend to add allegations regarding that would support Article 3 standing. And the court allowed amendment, and that's what plaintiff did. Plaintiff filed an amended complaint, and he alleged actual damages.
Did he ever ask for relief under Rule 36?
Withdrawal of amendment?
Mm-hmm.
He did not, Your
For
Honor.
the admission?
He didn't, and the reason he didn't was because almost immediately motions to dismiss based on lack of standing, I think it was 12B1 motions, were filed by each side, each defendant, I should say. And also, defendants filed a motion to stay discovery, where they argue that discovery is irrelevant to the issue of Article 3 standing. And the court entered that motion, apparently adopting that position immediately. For that reason, we thought that that signaled to us that the court's position was that this is just a facial attack, not a factual one, and the court would decide it on the allegations, not on the facts in discovery that are only in the record based on the previous version of the complaint. Also, plaintiff believed that allowing amendment to add actual damages was tantamount to allowing a withdrawal of the request of the.
That sounds like a heroic admission or assumption.
Sorry, the request to admit. I'm sorry, Your Honor.
It sounds like an heroic assumption.
Well, it's supported by the case of Gardner, the Seventh Circuit case of Gardner, which had pretty similar facts, and that's what we believed. It wouldn't make sense to allow amendment to add a claim, a prayer for relief of actual damages, if plaintiff was barred from doing so. Defendant never took issue with the amendment. The court didn't take issue with the amendment. It was allowed to go forward, but discovery was not allowed to go forward on the amended complaint. And that wasn't fair. If the court was going to decide the case, and based on a factual attack, which it seemed to do, even though the memorandum opinion seemed to only address the standard for a facial attack, it should have allowed discovery to go forward and complete, so that plaintiff could have gone in and filed a motion to withdraw the requested admission. But it didn't. It stayed discovery. And again, that signaled to us that discovery was irrelevant to the court's determination, because it was only going to determine, resolve the issue on the basis of a facial attack.
Your time expired a long time ago.
I'm sorry. Thank you.
Mr. Schultz.
May it please the court, counselor. My name is David Schultz. I represent Cone Law, as well as Catherine Byler represents Unifund. He asked some questions, and he followed up about how he would have paid. Okay, this is a factual situation instead of looking at the pleadings. And the facts that were demonstrated pretty clearly is, for 5 years before the lawsuit was filed, he was subject to collection activity and didn't pay. When the lawsuit was filed, he has no evidence that he called anybody to make a payment. No evidence to say he tried to clear up any confusion. No evidence that the lawyer he hired called and said he'll pay the $3,000. For 3 years, the collection case went on. Not one fact is alleged that he intended to pay that debt. In fact, the allegations are absolutely contrary to that. He's attached what he's filed in the state court. He denies the debt. Why is he going to sit here and say, I would have paid the debt, when he denies owing the debt? That makes no sense. It was not an injury. He's very clear. He was denying that he owed the money. He was denying that Unifund could prove it up. So an allegation, a few words that I would have paid but, is belied by the history of this and his actual conduct in litigation, and he adds nothing, no facts to support that allegation. The idea that confusion, which is really an ancillary of what he's saying, I would have paid it, is pretty clear at this point. Confusion is not an Article 3 injury. As are the other ones that he didn't really mention, the loss of sleep and stress. Being subject to collection activity is a stressful activity. Being involved in litigation is a stressful activity. Losing sleep is a consequence of those. I think every lawyer in this courtroom probably can say last night they were under stress and lost sleep. That's just the nature of being involved in these kinds of activities. It's not an injury, and there's enough cases at this point that nothing would support that. Hiring a counsel, again, he says that I hired it because of confusion, but putting that aside, just hiring counsel is not an injury. That's probably the best thing that had happened to him. That is what allowed him to get advice on what it is he was confused about. It can't be an injury. Why would he sit here and say participating in the legal process with competent counsel means you're injured? It's what allowed him for 3 years to fight off that case.
So your view is that if a debt collector blatantly violates the statute, making claims that are completely unjustified, and the target of that effort is confused, distressed, loses sleep, hires a lawyer who tells him, don't worry about it, they're in violation of the law, and they have not a legal leg to stand on, and the court will throw out their claims. There's no Article 3 standing for a claim under the Act.
I think there's enough case at this point that would affirm that what you just said is accurate. I think that also...
In this circuit, that's true. Would you agree that under constitutional law, we recognize standing for claims for emotional distress and invasions of privacy, for example?
I believe so.
And that the common law recognizes such injuries?
I believe so.
So
well,
why not,
emotional distress is
actionable under the common law, right?
Right.
So why not under the Fair Debt Collection Practices?
He hasn't alleged emotional distress here at all. Matter of fact, he was asked in discovery, in interrogatories, request to produce, and request to admit. Do you have any emotional distress? What is it? And he's answered unequivocally, none. He's asked, do you owe this money? No, I deny I owe this money.
If he had answered that differently, do you think we would have standing?
If he had answered and established, well, we are in a factual inquiry. They have to establish that the words statutory attorney's fees and a wherefore clause caused emotional distress and supported that with facts. Possibly, it might be a different scenario, but he's absolutely completely contradicted that, though. So we're not there, and he had plenty of time. He answered the mandatory initial discovery. He answered that. Nothing about damages other than statutory. I mean, as I said already, the interrogatories request to produce, request to admit. That's the record, and it makes complete sense. I don't think anybody could say there was a wherefore clause that talked about statutory attorney fees, and that's what sent me over. That's what caused me the emotional distress sufficient for the pleading requirements to establish emotional distress. It makes no sense. I get that he was subject to a lawsuit, a collection lawsuit. If anything, based on his denials and discovery of owing the debt, that could be traceable to the damage you're talking about. That could be. But it's way too tenuous, speculative, and absolutely contradicted by the record that those 3 words in the wherefore clause are what caused any such injury. And I think Judge Coleman hit it, amongst other things, right? When she said that's such a cynical view of what would happen in the collection case. She was a former state court judge. She probably knows. It's not like they're novices. This is what the judges do all day long. They're not going to just award money in a wherefore clause because there's a couple words there. And they never did that. If there was such a serious, those 3 words were so serious, in 3 years of that litigation in the Circuit Court of Cook County, did his lawyers do anything in regards to striking that? He certainly alleges nothing. They didn't. They never challenged it. The only challenge was to the debt itself. At this point, the items of injury under the case law here, and even under scenarios you're talking about, have been rejected, and there's not enough facts to even come close to establishing any of some of the cases you talked about.
Would you agree that the plaintiff's original complaint was sufficient to allege standing under our circuit's case law at the time it was filed?
It was filed 3 months after Casillas. It was filed many years after.
Casillas was a Fair Credit Reporting Act case, right?
No, it was a Fair Debt case. It was a G case, a 692G case, Casillas. By that time, the Article 3 issue was bouncing around. He specifically had on page 1 or 2 of his complaint a whole section called standing. He knew about it. Everybody knows about it. Everybody knew about it in this field of law. even before the opinion came down, that was what was being done. And then he alleged facts later. The claims and the causes of action, all the facts that support those never changed. In the first pleading to the second pleading, he added a few bells and whistles to try to establish some type of an injury, but nothing really new changed. And again, it was not sufficient. So I don't believe the original complaint was sufficient. No, the defendants, the Cohen firm, we filed a motion to dismiss on the merits. We think the case is pretty weak on the merits itself. And Unifund filed the 12B1 motion, so we kind of came at it both ways. We were comfortable with whatever way the court wanted to go.
Thank you. I stand corrected. I was looking at Casillas, so I was confusing it with the Fair Credit Reporting Act case.
Yeah. Well, that was the genesis of a lot of them, especially in the Supreme Court, where the FCRA cases, obviously Ramirez, you know. And in laws, I recognize the laws changed somewhat, but one of the things that's been discussed in some of the dissents,
It's changed a lot.
the landscape's moved a little, okay?
180 degrees.
But one of the comments that have been made in some of those dissents is, you know, you're shutting down the courtroom, and I can this is not in the pleadings necessarily, but
I'm sorry?
By taking this position, somehow the court is shutting out, you know, people from the courtroom, and I can guarantee that's not the case. And I practice in the Seventh Circuit, Illinois, Indiana, Wisconsin. We've got offices there, as in other places, and I can guarantee that these rulings have not slowed down the filing of fair debt cases. And there are many being filed in the Circuit Court of Cook County and elsewhere in Indiana and Wisconsin. These rulings have not hampered that or slowed that down. In fact, there's also been many arbitrations under AAA under these cases. A lot of the smaller individual fair debt cases are being processed that way fairly quickly. So these rulings, to the extent it's relevant and comes up in some of those dissents, you know, I want to clarify that I don't believe anybody's being harmed or losing their rights to prosecute. It may not be in federal court sometimes, but we were also in state court a lot anyhow before with counterclaims and other reasons.
What are the state courts doing on standing questions in these
Well,
cases?
so Illinois was Illinois, as we probably know, is a pretty low bar, like New Jersey. Wisconsin seems fairly low, although there's some cases bouncing around with that. Getting to, I believe, the Wisconsin Supreme Court on these fair debt types of cases, we'll find out. So they're not being knocked out, that's for sure. We're litigating them. So, for instance, I'm not sure you haven't seen these, but a whole slew of types of cases on the FDCPA, a Hunstein case, others, they're being litigated on the merits in state court. So I think my time's just about up. I appreciate it. We request that the order be affirmed.
Thank you very much. Mr. Casello, your time had expired, so we'll take the case under advisement.
Thank you.
And move to our last case this morning. Arundel Corporation versus Excel Energy. All right, Ms., is it coffee?
It's koi, but you would never guess. But ignore all the letters, and it's like boy. Thank
Okay,
you.
Thank you. You may proceed.
May it please the court, Jennifer Coy for petitioners. The district court certified a class without engaging with Rule 23 evidence or disputes. Plaintiffs tell you that that doesn't matter because in their view, having a Daubert qualified expert is enough to satisfy Rule 23. It isn't. Vacator is required for two reasons. One, just because evidence is admissible does not mean that it's persuasive or carries a particular burden of proof. But Rule 23 imposes a burden on plaintiffs to prove predominance by the preponderance of the evidence. West, Szabo, and Parco from this court make clear that that requires the district court to examine what the Rule 23 evidence actually shows, to resolve Rule 23 disputes, and to, quote, investigate the realism of plaintiff's common impact theory in light of defendants' counterarguments. Two, that didn't happen here. The district court here, which is now recused, first referred to the MDL court's Daubert opinion. that opinion omitted all sides' experts and then denied certification. The district court here then tells us in a conclusory fashion that plaintiffs have a facially credible theory. It's on page 21 of the opinion, and the court stops there. But Rule 23 is not an evidentiary admissibility standard, and it is not a just take the evidence plaintiffs say at face value.
So, Ms. Coy, let me start this way. One of the common questions here is whether the defendants acted in concert to manipulate prices, correct?
We would dispute that, but that's not the issue here. For these purposes, we're focused on antitrust injury. Yes, Your Honor.
I'm trying a bank shot, so bear with me just a moment. Would you agree that that is a common issue, and whether it's a common issue is central to whether the class can be certified?
Whether there's a conspiracy?
Whether there was a conspiracy, yes.
It is our position that that is, in fact, not a common issue, Your Honor, but that is not the focus of our appeal. Our focus of our appeal is on antitrust injury.
I understand, okay? I'm trying to get across, let me just be very blunt.
Right.
Does the plaintiff have to prove the conspiracy to get the class certified? Or do they simply have to prove it's common evidence for all the defendants and all the plaintiffs?
Absolutely, Your Honor. The plaintiff
That's good enough, right?
Yes, the plaintiff does not have to prove the merits of the ultimate question of conspiracy or antitrust injury. And this is a critical issue that I'd like to address. The dispute here is not the merits question of can plaintiffs actually show antitrust injury. The dispute here is do plaintiffs have a common method of proof of antitrust injury? The core dispute here is essentially is predominant satisfied? Is there a common method to prove this, or instead will individualized issues predominate the question as to antitrust injury?
Well,
and
so
that's
the counterfactual here, right, if certification is denied on this basis, would be that antitrust impact or antitrust injury would be litigated individually, correct?
Yes, exactly, Your Honor, which is what's key under Amgen and Dansel and the court's precedent, is that the reason this issue has to be addressed now and vacator is required is because this is not, as what plaintiffs tell you, an up-down on the merits. Consider these two examples. Imagine that the district court on remand determines that plaintiffs have not shown what they say they've shown, which is a cohesive market that moves up and down together so common proof can in one stroke prove antitrust injury for the class. Well, if they haven't shown that, that doesn't mean that no plaintiff can prove antitrust injury.
Right, so the alternative is individual trial by individual trial with these same experts debating antitrust injury for a particular plaintiff, correct?
Not necessarily with these same experts, but perhaps, yes, but it all will come down to the individualized factors of how, when, and where any individual purchased and individualized issues of antitrust injury will predominate. And Your Honor, I'd like to show you the point on the flip side too. Imagine a potential situation where in a different case, the plaintiff's expert did show a national market that was cohesive and moved up and down together. Well, in that instance, the fact that plaintiffs could prove that with their experts does not mean that they will prevail on showing antitrust injury. So of course, you can certify a class that will win or will lose. What that means is purely that they would have a common method of proof, that individualized issues would not predominate, because in that instance, they could show injury on a class-wide basis, and whether they actually show it or not would remain to be seen. And the core point here is that this is an issue that had to be addressed head-on right now under Szabo, West, and Parco, because this is the core question of have they shown predominance, which they have a burden to prove. And I'd like to give you some concrete examples of what the district court should have grappled with here, but didn't. Plaintiff's theory is that they have this cohesive market that moves together across everywhere, and so the same proof could take a class member who purchases with a fixed price on the first day and could prove injury for that class member and somebody who purchases on the last day in a different location with a trigger purchase price method. And the question is, have they actually proven that? Well, let's look at what their evidence actually shows. Their evidence shows, their own experts say, that the prices don't move together. In fact, that when fixed prices are up and show impact, then monthly index prices are down and don't show impact. If you look at Harris's Exhibit 7, what it shows is at most sporadic impact.
Could Judge Conley have done a rigorous analysis without disqualifying these experts?
Yes, absolutely, because Daubert is a completely different inquiry than Rule 23. So absolutely, Your Honor, and that's precisely what the MDL court here, said, I'm going to admit all of these experts, but certification isn't warranted. And the core point here at plaintiffs, because the court's order is so thin and conclusory and doesn't contain any engagement with two sides of complex rule certification, Rule 23 fights, because it's so thin, plaintiffs tell you, well, Daubert is enough. But every case to address that issue tells you Daubert is not enough. Daubert is a gatekeeping function that looks at, is the methodology reliable? Is this junk science? Does this use econometrics? It doesn't look at the results coming out and whether they carry a particular burden of proof. But Rule 23 imposes an evidentiary burden of proof on plaintiffs to prove predominance by a preponderance of the evidence. And let me give you an example there too. Imagine that there's an expert who wants to rely on an x-ray to show damage to a leg. That expert relying on the x-ray makes complete sense. If an x-ray is a time and a tested method that isn't subject to challenge, that is not scientifically reliable. But what that x-ray actually shows is the Rule 23 question. Once you've already passed Daubert and said this is admissible, then the Rule 23 question is a completely different inquiry of, does this evidence, with its flaws as it is, taking this evidence, does it prove predominance? Does it prove that antitrust injury is capable of being proven for the whole class through common proof? And it doesn't. And taking you back to some concrete examples.
When you say it doesn't, are you talking about the decision doesn't, or are you talking about the proof?
The proof, and the proof is the key point, because if you look at page 21 of the district court's order, what you see is the court is taking plaintiff's theory at face value. It is doing exactly what Parco says you can't do. Parco says you have to investigate the realism of this injury model based on the counterarguments. And that's what doesn't happen here. I mentioned the problems with plaintiff's evidence in and of itself not showing what they wanted to show. But think about what the defendant's experts show. Defendant's experts show that plaintiff's common impact theory is completely divorced from the reality of the evidence.
Is there a circumstance in which there could be a rigorous analysis engaged in by Judge Conley, which would have resulted in a class certification decision that would have been a more robust decision here?
Yes, Your Honor. It's our position that when you actually consider this record, that you couldn't certify a class.
Okay. Now, what about? Go ahead. I'm sorry.
But our fight here is not saying that you need to go study the evidence and agree with us on that. Our fight here is that this court's precedent and the Supreme Court's precedent is clear that the district court has to engage with all evidence and actually examine it and resolve the disputes underlying Rule 23 predominance to determine whether plaintiffs have actually proven predominance. And there's a great line from the Pretty case that says at the very end that explanations matter and complex rule certification issues can't be decided by judicial fiat. And this court's Santiago case is on board, and the Fifth Circuit's recent Chavez case really explains the point. And this isn't just some silly requirement foisted on busy judges. This is because real important issues are at stake.
So, Ms. Coy?
Yes, Your Honor.
Sorry, you were wound up. I wasn't sure. Go ahead and finish it up.
Class actions are the exception to the ordinary rule, and so the stringent requirements exist to prove that you can have a class action.
We agree Rule 23 is important. Could I ask you to address the Tyson Foods case? In particular, this passage, which is at 577 U.S. 459. Once a district court finds evidence, this is on a predominance issue, or on a class issue, to be admissible, its persuasiveness is in general a matter for the jury. This is about the donning and doffing survey. Reasonable minds may differ as to whether the average time this expert calculated is probative as to the time actually worked by each employee. Resolving that question, however, is the near exclusive province of the jury. The district court could have denied class certification on this ground only if it concluded that no reasonable juror could have believed that the employees spent roughly equal time donning and doffing. Why doesn't that reasoning tell us that all of the debates between plaintiffs and defendants experts about this really should wind up going in front of a jury to resolve whether plaintiffs can actually prove antitrust impact at trial through common proof?
First, I see my time is already into my rebuttal time. May I
Please
continue to answer? Okay, absolutely, Your Honor. And first, I'll say I point you to the Lambdical opinion out of the Third Circuit that directly addresses this point head-on in a completely on all fours analogous antitrust case. But the answer is twofold. Number one, Tyson Foods was a unique FLSA context case with burden shifting. There, first of all, the court was looking at the merits issues, not at Rule 23 issues when it made that statement. And the unique burden shifting aspects there were that defendants had a burden to keep records. And when defendants didn't actually keep records in the FLSA context.
The comment here, though, is with respect to class certification or, in the FLSA context, a collective action, right?
Right, Your Honor.
So what that's telling me is we're in this very delicate area where class certification decisions by the judge are overlapping, intruding upon merits issues, and it's telling us be careful and, in essence, defer to a jury's power to decide that issue.
Yes, Your Honor. This is not going to the merits question. As we discussed earlier, the merits question is, can you prove antitrust injury? This is purely the Rule 23 question of, do they have a common method of proof? Having a cohesive market is not an element of their claim, unlike what they were discussing in Tyson's Food. Having a cohesive national market, what the fight is about here and what needed to be addressed is purely their method of showing predominance, showing that they have a common method to prove antitrust injury. And let me be clear, that issue never goes to the jury.
How is that different from the Tyson question, which is, can plaintiffs prove their donning and doffing through this survey?
Because in Tyson Foods, and Lambdical explains this, and there's Tyson Foods can't be read.
So Lambdical seemed pretty reluctant to go along with Tyson Foods on this.
And this court since, when you look at Gorse Motels and Howard, countless opinions coming out after Tyson Foods, and the U.S. Supreme Court, Goldman Sachs, nobody has read Tyson's Food to overturn the entire Rule 23 system, which is what would be happening there. Because in an issue like this case, the core fight here is not the merits question of can they prove antitrust injury, but have they proven by a preponderance of the evidence that antitrust injury is capable of being proven through common proof at trial. And Tyson's Food was addressing the unique FLSA context where when the employer didn't keep records, the burden shifted. Plaintiffs didn't have to actually prove anything because the representative sample was allowed to be used, and it was a completely different circumstance. And in that instance, the question went to the merits because the representative sample, the fact that this was a common issue was already a baseline in that unique FLSA context. Here, if you look at, I point you to the court, to hydrogen peroxide, to Zabo, West, and Parkway. I see my time is up, but Tyson Foods can't be read to have overturned the entire Rule 23 construct and the burden of proof on plaintiff to prove predominance by preponderance of the evidence.
With my colleague's indulgence, I'd like to follow. We've got a lot of material here. And first of all, am I understanding correctly? We obviously, a lot of people paid, $340 million in fines. Other people, pled guilty. This is not an imaginary conspiracy, okay? Is the problem here unique of antitrust injury unique to Wisconsin? Would we face a similar problem? Is this about geography of where the conspirators were and were acting and manipulating prices?
There are aspects that are unique to Wisconsin because Wisconsin has, for instance, the unique situation in which the vast majority of the class didn't purchase directly from defendants. But the core problem here is that the district court didn't engage with the Rule 23 fight, and that could apply anywhere.
That's not my question.
Okay, I'm sorry.
I'm trying to understand why plaintiffs need to prove a national market given the conspiracy.
They don't, in theory. They don't. What they have offered is this theory, and the focus of our fight is not on whether it's national or not. They're saying that there's a cohesive market. They're saying that everything moves together, and that's their theory of why they can use the same evidence, why antitrust injury is capable of being proven for the whole class with the same evidence. Okay. And that's what the court didn't engage with, was have they actually proven that?
Okay, and then, thanks. And then could I also ask you, obviously the Supreme Court has told us in general that these sorts of cases usually are suitable for class treatment. And can you point us to horizontal antitrust cases where class certification was denied for lack of predominance?
Yes, Your Honor. The most on all fours case I can point you to is hydrogen peroxide.
Right.
And I also point you
Which
to...
is hard for me to reconcile with Tyson Foods. But.
Well, after hydrogen peroxide, you have Blood Regents agreeing with it. You have Lamticol. And if you look at the reasoning in clean products, for example, if you apply the exact reasoning here, that applying that reasoning to these facts requires vacator, because what the Supreme Court and this court's precedent says is that there needs to be engagement. And I'm not asking you, again, to rule that the class can't be certified. What we're saying...
You are, but it's understandable you're backing off of that position because I don't think that has a leg to stand on.
Well, we've asked for vacator, and the reason we've asked for vacator is because this court's precedent, including just in the past year, when you look at Gores, Motels, and Howard, this court's precedent consistently tells you that Rule 23 is not a pleading standard. You can't, as the district court here did, take the allegations at face value. You instead have to investigate the realism of what plaintiff's model of common impact actually shows in light of defendants' counterarguments. And when you read the order, you see no engagement or investigation of the model and its realism, how it's tied to the evidence, and the fact that it's in fact directly contradicted by plaintiff's evidence. And you see no engagement with defendants' experts' proof that in fact common evidence cannot be used to show antitrust injury.
One other quick question. We're here entirely under state antitrust law, correct?
Yes, Your Honor.
For the full consideration remedy under Wisconsin law, do plaintiffs need to prove antitrust impact under that statute?
Yes, Your Honor, under the Wisconsin law, if you look at Durzen and the City of Madison case. But, Your Honor, this highlights the critical point that I'm making, which is that the district court didn't engage with any of this. The district court didn't tell you what it thought about that, and I point you to this court's Santiago case on that point. Thank you, Your Honor.
Thank you very much. Mr. Billings.
May it please the court, my name is Ryan Billings from Courtroom Michaelis, SC. We represent the plaintiffs in the class of Wisconsin businesses and commercial entities certified by the district court below. The defendants would require us at the class certification stage to prove essential elements of our merits case. That would impose an unbounded, unworkable, unreasonable burden on busy district courts. It would also contravene settled guidance from the Supreme Court and this court that a district court should not delve further into the merits than required, that a district court should not turn class certification proceedings into a dress rehearsal for the trial on the merits, and most importantly, that a district court should not invade the constitutional province of the jury as the finder of facts. The test is wrong, it should be rejected, and the district court's opinion below should be affirmed. But stepping back a little bit, how did we get here? This case is in its 17th year. It spent 12 years in consolidated litigation before the MDL court. During that time, over several million pages of documents were exchanged, 160 depositions were taken, thousands of pages of written discovery materials were exchanged, and tens of thousands of pages of expert materials, reports, and supporting materials were exchanged. The defendants filed more than 40 dispositive and Daubert motions, leading to 6 appeals to the Ninth Circuit and 1 to the U.S. Supreme Court. There was a lot of water under this bridge before this case ever came back to Wisconsin. And importantly, by the time this case was transferred back to the district court below, at least 2 courts had rejected every single substantive criticism that defendants offered to the work of plaintiffs' experts. First, at defendants' insistence, before the MDL court, class certification and Daubert were briefed and argued simultaneously. The defendants made the same arguments in both briefs. In the context of their Daubert motions, the MDL court rejected these criticisms. It said that plaintiffs' experts satisfy Daubert muster, they meet all the requirements of Rule 702, they're based on sufficient data, reliable methods, reliably applied to the facts of this case. Second, when this case went up to the Ninth Circuit on class certification, defendants made the same arguments again, and the Ninth Circuit rejected them as well. It said these speak to damages, and individual damages questions as a matter of law cannot defeat class certification. This was settled law of the case before the district court even began to consider plaintiff's 2020 motion for class certification. In its decision, the district court accurately recited this history, it correctly articulated the principles governing class certification, and it addressed the primary legal and factual challenges the defendants raised to certification in this case. Legally, defendants argued that the fact that plaintiffs' experts passed Daubert muster is not in and of itself guarantee automatic certification of a class. The district court addressed expressly this argument and agreed with it, commenting fair enough. And with all due respect to our opponents, we do not argue that Daubert, satisfaction of Daubert itself gets you a class. We have never argued that. What we argued was in the question that the court asked us, which is whether the district court properly assessed the parties' expert opinions. Every court of appeals that has been asked the question, what should a district court do when competing expert views are critical to class certification? Every court of appeals has answered it the same way. It has said, do a Daubert review. And that's what happened here. The district court also addressed the primary factual dispute, whether, as plaintiffs allege, there's this uniform national interrelated market in which rising prices anywhere affected prices everywhere, or as defendants assert, there is no such market. And pricing was predominantly, it varied by location and it varied by purchase method. The district court addressed this dispute 7 times in its opinion in the context of 3 separate Rule 23 factors. It grappled with this issue. And what did it say? It said 3 times. Plaintiff's theory is premised on a single national market for natural gas. That's on page 23. It made the same comment again on page 21, and it made it again on 23, and it made similar comments twice in 21, 22, and 26. 7 times. It said that is the foundational premise of the Harris-Dwyer model, or the HDM, by which we intend to prove antitrust injury. If that premise is incorrect, then the model fails. We can't be half right on that. We're either all right or we're all wrong. And for that reason, regardless of what the jury thinks of this, the jury says, plaintiffs, you're absolutely right. Or if the jury says, plaintiffs, you're absolutely wrong, the result is going to be common to the class regardless of how it is resolved. And for that reason, the district court concluded that that dispute is not material to certification factors because the law is settled that a class can be certified if it's doomed to fail just as easily as if it's certain to win. That opinion is entirely correct. Now I want to address a couple of questions that the court raised in response to my opponent's argument. One funny story, Tyson Foods 459, right on the top of my outline, because that is the key question. The Supreme Court answered it. It said, once a district court finds evidence to be admissible, its persuasiveness is in general a matter for the jury. And the standard is whether no reasonable juror could find in the evidence that the plaintiffs are correct. That's the standard. We don't have to prove on the merits that our expert opinions are more persuasive. We don't have to show that more likely than not we can establish antitrust injury for every class member. That is not the standard. How do we know that? Because the court said that in Messner, Judge Hamilton's decision to which Chief Judge Sykes joined. That case was...
Doesn't matter, and it was a long time ago. Doesn't matter who wrote them, who was on them. It's a decision of the court.
Okay.
So what do you say to the defendant's points that your own experts' data shows supposedly related prices moving in opposite directions, depending on geography, depending on price, on pricing methods?
That's two different questions, but I will address both of them. So their argument that the prices move in opposite directions, that is a very specific phenomenon which we addressed in our brief. And this is about monthly index prices getting stale towards the end of a month. Dr. Dwyer noticed you have this index price. It comes out at the beginning of a month. And that index price may be trending downward. But if you see at the back end of the month prices going up, then the fixed price is likely to go up even though the monthly price is going down. That's just because it's more dated. It's old information. It's a temporary phenomenon that's easily explained. Dr. Dwyer went through that. As to geography, Drs. Harris and Dwyer both said that this is a fungible commodity that is traded by standardized contracts in highly liquid hubs all over the country. Every second that we are talking, there is gas moving from Texas to Wisconsin because Wisconsin does not produce, or did not during the class period, produce any natural gas. It would not make economic sense for there to be persistent discrepancies in natural gas prices by location. If the price in Henry Hub, Louisiana, is very high and the price in Chicago is very low, then what's going to happen? People are going to sell at Henry Hub, and that will bring the price down. Prices will equalize over time. They're not arguing that they move in lockstep. They're not arguing that they move uniformly, but they are arguing they are highly correlated, and simple foundational economic principles suggest that is so. That's what happens with a classic commodity like this. I do want to return to Messner, though, because it does give us the answer to the question why the defendants are wrong. Now, we pressed the defendants in our Appellate brief to explain exactly what. What fact did the district court need to find that it didn't? What proof do you assert that we have to demonstrate in order to certify a class? And we finally got the answer in the reply brief. Reply brief, page 18. They argue that plaintiff's burden is to show that antitrust impact is, in fact, common across various indices, locations, and purchase methods. That is a key element of our merits case. That is what they're arguing that we have to show. What happened in Messner? That was an antitrust case involving a hospital merger. The district court refused to certify a class. It went up to this court. This court reversed. The key issue was predominance, and specifically antitrust injury. And what this court ruled was that the district court below required an overly strict standard. It required a heavy burden of proof that is not what the law requires. Why? Because the district court argued that unless the price increases were uniform across different contracts negotiated with different providers for different services that changed over time, unless those price increases were uniform, no class could be certified. This court said that's an error of law, and it reversed. And it said, and I quote from page 818, under the district court's approach, Rule 23b3 would require not only common evidence methodology, but also common results for members of the class. That approach would come very close to requiring common proof of damages for class members, which is not required. To put it another way, the district court asked not for a showing of common questions, but for a showing of common answers to those questions. Rule 23b3 does not impose such a heavy burden. We have common evidence. It's defendants' own sales. It's defendants' own false reports to the trade indices. We have a common methodology. It's the Harris-Dwyer model. What defendants challenge is whether our results will be common to every class member. We don't need to show that, and in fact, we don't need to demonstrate that every class member was injured in order to certify a class. That is not our burden. That is not the law. Every court that has squarely addressed the question at issue here, which is, when you have these conflicting expert disputes, what do? You do a Daubert review. That happened here.
Well,
that satisfies.
That's necessary but not sufficient is the principle.
Correct.
That emanates from those cases, right? And Judge Connolly appears, it's a little unclear, but it appears as though he was treating that as sufficient, that admissibility establishes what needs to be established under Rule 23 without further inquiry and evaluation of competing views of the defense expert. Just because there's facial plausibility to the plaintiff's experts isn't enough, but he treated it as enough once he adopted the admissibility determination of the MDL court.
I respectfully disagree with that assessment, and let me tell you why. So he talks about Daubert in one section and then goes into the Rule 23 factors in a different section. In that Daubert section, he uses the words facially credible, or maybe a credible theory. But what he's answering is the question, well, the fact that you satisfy Daubert does not automatically mean you can certify a class. He agrees. Fair enough. But they have a facially credible theory. It at least gets to a jury. The evidence that we intend to present, whether or not it's 7 plaintiffs or a class, is going to be the same. We are going to present the Harris-Dwyer model. That is how we show antitrust injury. We just would like to take the class members with us on that journey.
This case looks an awful lot like hydrogen peroxide. You want to address that? Do you have to disagree with it?
I very much disagree with that. First of all, in hydrogen peroxide, the plaintiff's expert said, I don't have a model for antitrust injury, but I will come up with one later. Trust me. And the district court said, that's enough. In that case, the district court believed it was legally prohibited from considering the views of defendants' experts. That is an error of law. The Third Circuit was also cleaning up precedent which suggested that you are absolutely forbidden from discussing merits issues, and clarified that when they touch on class certification, you might have to go there. And in addition, it was not like this case because it wasn't a single product that was completely fungible, sold the same way, used for the same purpose, you burn it. It was several different concentrations of hydrogen peroxide that had fundamentally different qualities, were sold in different markets, used for different purposes, and there were 2 other products actually involved, sodium percarbonate and sodium perborate. Several different products. There was no model of antitrust injury presented to the court, and the district court seemed to view the plaintiff's expert's affirmation that it would come up with a model later as sufficient. How do we know that that is not the controlling law in the Third Circuit now? Because 7 years later, in the case of in-ray blood reagents, when the question came to the court, what do you do when competing expert views are critical to class certification? It said, what every other court of appeals to address this issue has said, do a Daubert review. And returning back to Chief Judge Sykes' question, at the beginning of the opinion, he talks about Daubert and why Daubert does not get you to Rule 23. Then he lays out the Rule 23 standards and says the plaintiff must demonstrate Rule 23A and the requirements of Rule 23B. He says this is an evidentiary standard. He says if there are disputes of fact, I may be required to hear evidence and resolve them, citing this court's decision in Messner. But then goes on to say, but by the same token, I am not permitted to turn class certification proceedings into a dress rehearsal for a trial on the merits. That is what defendant standard would require. Because to get to antitrust injury, you have to start with how is the market structured? How did defendants manipulate it? How did that manipulation cause antitrust injury? That is 3/4 of our case on the merits. All that's left is damages. So we have to build up from the ground up that entire model and convince the district court it is true and it is more persuasive than defendants' contrary view to certify a class. That is not the law. We know that. Tyson Foods very clearly said that the standard is not you have to show your merits case by a preponderance of the evidence. The standard is can any reasonable juror side with you at trial? And I go back to where I started, which is those 40 dispositive motions. This case has been tested every possible way. It has survived every such test. We are taking this case to trial, and the MDL court ruled repeatedly that if the jury believes the evidence we have put forth, it may end judgment in our favor. This is not a case that is based on illusory conduct. It is real harm to the class members in Wisconsin. The case has been battle tested. It has been proven that if the jury believes our evidence, we will succeed. And I turn to the court's decision in Clean Products that said the standard is whether the evidence, if believed, could show antitrust injury through evidence common to the class. Our model can do that. There are complaints that defendants make, complaints rejected by 2 separate courts, the Ninth Circuit and the MDL court. But those complaints do not undermine the fundamental premise of the model and the fundamental reliability of it. And if you look at our brief, every time the defendants are specific about what's wrong with our model, we have an answer with a citation to the record. And that's why those courts rejected it, and that's why there is no phantom problem with this single market rule. Thank you.
Thank you. Ms. Coy, your time had expired, but I'll restore some of it because we kept you at the podium, so you can have an additional 3 minutes to rebut.
Thank you so much, Your Honor. I really appreciate that. Plaintiffs point you to the court's order, but I want to emphasize, and if you look at page 21, you'll see that what the court does is exactly what Chief Judge Sykes says, is the court cites the Daubert and then takes plaintiff's theory at face value. The court uses the word facially credible and just takes it without actually engaging and analyzing. For instance, the fact that these models plaintiffs say they have don't even apply to the named plaintiffs who are supposed to represent this big class. How could this actually show that antitrust injury is capable of being proven for the whole class? Our point here, they dispute all sorts of facts. They say they have answers. We say they don't. But our point here is if you look at Szabo and West and Parco and Howard and Pretty and Gorse Motels, and the list goes on, what this court's precedent to date tells you is that the district court has to actually engage with the Rule 23 disputes. The district court has to actually examine both sides, all, as Goldman Sachs and Allstate tell you, has to examine both sides' evidence to see if it actually proves predominance by the preponderance of the evidence. And that's what's lacking here. The order contains no analysis, no engagement.
So if the district judge, if we send this back and the district judge says, in essence, plaintiff's model looks, I've looked at all these reports, plaintiff's reports look pretty good to me. I think there's a national market here. You want to be able to dispute that in front of the jury, correct?
There might be some overlap with the merits, which this court and the Supreme Court has said is not a barrier to the Rule 23 issues. But no, we will not be able.
But you want this to be, in essence, heads we win, tails we don't lose, right?
No, Your Honor, in the sense that we will never be able to argue to the jury whether or not there is a cohesive market that moves up and down together such that common proof could satisfy the entire class in one stroke. And that's why Rule 23 imposes such a rigorous analysis requirement here. If in the real trial, they have a plaintiff come who uses their evidence to show, okay, here's how I bought gas, my method, my way, and then that's supposed to prove for other class members, that's a real problem if they haven't shown that they have a method that works to actually show that everything moves together.
Let's assume the class has been certified, that the district judge resolves the factual issues that you say need to be resolved here, full engagement, and Judge Peterson rules in favor of class certification. So as plaintiffs have shown, the Harris-Dwyer model works, and there's a national market. You want to be able to dispute that at trial?
Again, we might dispute aspects of a national market, but we will not be able to dispute the core Rule 23 question of have they proven predominance. And that's the key issue. If this were the merits question of have they proven antitrust injury, then to your point, this would go to the jury. There would be no place for the district court to be analyzing that. But this is not the question of can they prove antitrust injury. It is the core question of, as Dansel put it, do they have common proof? Their question is there common proof of antitrust injury? And that will never be addressed by the jury. That is purely the role of the judge to address in the Rule 23 context, and the jury will never be given the opportunity to revisit that question. And so that's why this has to be addressed now, Your Honor. Thank you so much, and we request that you vacate the district court opinion.
Thank you. And thanks to all counsel. The case is taken under advisement, and that concludes our calendar for today.